Hello and welcome everyone. Welcome to the open mic number 248. And welcome Sunshine Christine. You made it during the intro.
I know. Well, I checked at like 6:55 and there wasn't a link. And I was like, you know what? Let me log completely out and log back in. And then, of course, my dog always has to, he's like a human. So, yeah, I'm like super happy that I'm here at the start. That's like something I've been shooting for. So,
Well, you literally didn't miss anything because I was late. And I was trying to hurry and get done, but I was still a few minutes late. So you didn't miss the link. It was me.
oh, well, that's good.
Yeah, well, not really. I don't like being late, but sometimes it happens. And
Yep.
so
Oh.
really good, interesting set of conversations last night, and or talking about different things. It wasn't just one thing. We talked about a lot of things. So I appreciated that. Yeah, I certainly appreciated that.
I really enjoyed it. I have missed our chats, to be honest with you. This is kind of personal. I didn't realize how isolated I was becoming yet again. And, because I'm separated, I'd say I'm getting a divorce, but we were never married. But I'm finding that, because it's so interesting to look back at how you don't even realize you're being manipulated into not communicating with people.
Sure.
and you don't see it until it's over, and then you realize, wow, they had done, and so I'm just grateful that y'all left the door open, where I was comfortable coming back. And so that's, plus life being life, we've all had a lot of things going on.
Oh yeah.
But at the same time, I'm just happy that, that we have a really genuine connections, and it was comfortable.
Now, wait a minute. Now, wait a minute, Sunshine Christine. Now, we're supposed to be a cult. I'm just saying.
That's right.
Yeah.
I forgot. But I
Somebody
didn't get the memo.
Yeah, apparently I didn't either. So I'm just telling you that's out there, that we're a cult and people have to do what they're told, and just all kinds of crazy stuff.
Yeah, I've found that when people, especially in these wrongful conviction plot cases, I have found that there is a lot of pot calling kettle black going on.
Yeah.
And and you can see it in the Stephen, with the Manitowoc County and the Wisconsin DOJ. 90% of the accusations leveled at Brendan and Stephen are actually them telling on themselves. And so that's how I look at it.
It's a lot of people follow the Karen Reed case, and I followed it, but I wasn't like, it wasn't like what I've done with this case. I wasn't into everything, but I followed it enough to see this diametric kind of same, different people, different players, but in her case, it's worse with some people, much worse. I mean, people that took direct action in several situations. It's crazy, absolutely crazy.
Yeah. It's interesting you bring that case up. There was a video someone from that case that's following that case posted a couple of weeks ago. I guess the judge like halted proceedings over, and the way it was worded, she made it sound like the defense had potentially done this egregious act, but yet just in the short video where she's reading the quote allegations unquote, it's prosecution has potentially made it where this, and I haven't followed the case enough to know where they're at. I know wasn't there a mistrial or a hung jury or something, I believe?
Was a mistrial because they couldn't. There was whatever, not 9-3 or whatever the number was. They couldn't get a unanimous decision. 9-3 to acquit. The problem, one of the biggest problems with that case, with that though, is that the judge didn't follow up with the jury to make sure that those ballots or those whatever, not ballot, but the forms were filled out correctly and signed on what they acquitted her on, which was well, whatever there was a few charges that they acquitted her on. There was one though that they hung, but the forms weren't filled out. So that was her fault. She's the one that's supposed to do that.
Yeah. And just her attitude, like I said, like I really know the most of what I know I got from Susan.
She knows the case really well.
Yeah. And so she'll correct me if I'm speaking inaccurately. And I'm grateful for that. But they're all like just delusional. Everyone, it's almost like I don't even know. Thank goodness the media is on this case, because they were going to just, blame it on her. Yeah.
Yeah, this guy, Turtle Boy, I know you probably remember that name, Turtle Boy.
Mm-hmm.
He has been following those police departments up there for, I don't know how many years, but it's been quite a while. And he's exposed some things that were wrong. Anyway, he started following this case really closely and was finding out all kinds of stuff and was exposing it publicly. And they really went after that guy. They really went after him. It's beyond. Well, that's what I'm saying. That case there is kind of like this here, just amplified. They retaliated on that guy, in my opinion. That's my opinion. Anyway, I think he's out of. They got. I think they got him out of jail, or he's out of jail. On. I don't know what all's happened since. If I read it, I've forgotten it. But, and I don't know how closely this will be, how correct it will be. Starting tomorrow night, Monday night here, on the ID channel, they got the Karen Reed story coming up, documentary or whatever, on the ID channel.
Oh.
Yeah, I may try to watch it. I'm interested to see how they will treat and expose a lot of the things that happened that we know is factual, or if they'll just ignore it. We'll see. That guy Proctor, he was state patrol guy. He helped sink that case for them. This guy's making $180,000 a year, and the things that he was doing. Oh my God! Anyway, I'm going to get off sideways here. Hey, there's
Yeah, I'm curious to see if the ID channel is going to be unbiased,
Correct.
or if they're going to defend the state.
Correct. That's what I'm waiting to see.
Because that's going to say a lot about how the media is, where the media is at, and I say that simply because most of mainstream media, and that includes these channels, are owned by the uglier, the 1% behind shell companies. So,
Right.
and
Manslife says that the judge instructed the jury to not fill out the form until they had a decision on all charges, which was wrongly instructed and has caused the current issues with the Karen Reed case. Thank you very much. That's awful. Hey, let's say hello to Donna Wolfwich and Travis. Hey, Travis. Jay, Nan's Life, of course. Sheila, Gloria, Pete Moss. Well, that's all I see right now.
yeah.
Anyway, unless there's something pressing, I think this document here that I'm fixing to pull up is, of course, Judge Andy's memo and order decision, whatever. The Karen Reed case is about, he was a state or maybe a Boston police officer, or I think he was either a Boston cop or a state patrol. I don't remember which. Anyway, Karen Reed was dating this guy, and her and him and several others went out drinking one night a few years ago, and I think there may have been a little bit of fussing, whatever was going on. Anyway, they decided they got done. They drank for, I guess, quite some time at this one bar, and they decided to leave and go back to another police officer's house, whether state patrol or Boston cop. I can't remember. Anyway, Karen didn't want to drink anymore. She was done. So she dropped the boyfriend off at this house. And then she leaves. She's pretty drunk herself. She leaves and goes home. He says, I'll have somebody bring me home here in an hour or so. I guess she wakes up at 4:30 or 5 o'clock, and he's still not home. Can't get him on the phone. So she drives back to to that house. And anyway, I don't know exactly what happened at that point in time. She didn't find him. Anyway, this party starts breaking up at some point after that. Well, they find this guy outside dead.
Allegedly.
Yeah. They found all kinds of marks on this guy. Looks like he's been possibly attacked by a dog, which that guy that owned that house had some kind of dog. And anyway, of course, there's an immediate response from state and local cops. Well, they ended up allegedly finding various pieces of a tail light. Anyway, they ended up blaming Karen Reed. Said she was mad at him and backed over and hit him with the car. And I know that they had at least one medical examiner on there and said, no, that's not marks from my car. There's no bruising at all. Like I said, this guy, from what I remember watching and seeing in these other YouTubers talking about these marks on the body of this guy, it looked like he'd been bit and beat and, not hit by a car, because that causes bruising. And anyway, so they blamed it on her, took her to trial. That's the high notes. There's a whole lot more to it. This one guy, Proctor, that I mentioned, like I said, he's a state patrol officer, and the things that he did. Oh my God. Just searching her phone for nude photos and, et cetera,
Tried
et
to
cetera.
seize her dad's phone, I remember.
Yep.
Months, yeah, like months into the trial. It's
Yep.
just
And
craziness.
there's a couple of cops that they were going to seize their phones that were associated with the case. And miraculously, right before they seized their phone, these guys ditched they destroyed their phones. Destroyed them.
Yeah,
If that's not telling there, I don't know what is.
yeah.
Hey, there's Doc. What's up, Doc?
Hey, Doc.
Hope you're feeling okay, little Barb. What channel? Oh, it's on the ID channel, little Barb. This new documentary about Karen Reed. Tomorrow night at I'm in the Eastern. Me and Sunshine Christina are in Eastern time zone. So if you're more west, you'll have to start taking hours away. 9 Eastern on the ID channel. Anyway, that's what that case is about, and it ended in a mistrial because they couldn't. There were, I think, 3 separate charges. They acquitted on 2 of them, but I think the one on manslaughter, or no, maybe not. I don't remember, but there was one of the charges. There was they couldn't make a decision. They couldn't come to a unanimous decision, I should say. So but there's so much that's happened in this case. It's crazy. It's so complicated. It's just as complicated as the Avery and Dassey cases, and more venomous in many ways with a lot of the things that happened to people outside of the case. Like I said, Turtle Boy, they really went after that guy. Oh my God. Anyway,
I mean, and it's just so bizarre that they doubled down like that. And, after it, they acquitted almost on all the charges, right?
yeah, pretty much. Except for Travis says there's 4 charges. Okay. I was thinking 3, but one of them, whatever it was, they couldn't make a decision. And Gloria, it took place right outside of Boston, like a little burb there, but it's still Boston police that responded. It's not right in the city, I don't think. I think it was just right outside a little burg, whatever the name of the town is. I don't remember. So yeah, it's a really interesting case. I'm sure all of the trial can be found on YouTube if anybody wants to go back and watch it. It's just insane, and you'd be absolutely blown away. I'm telling you, by this guy Proctor, the state trooper. If you watch him, you'll be blown away by his testimony. I couldn't believe it. I absolutely could not believe it. I think a lot of us were in shock, kind of like watching the Depp and Heard trial, civil case. Oh my God, that was so bad. Anyway.
Oh, yeah, that trial is a hot mess.
Mm-hmm.
Oh, and what do y'all think about this? Is the Gene Hackman and his wife and his dog being found deceased? They said that there was no carbon monoxide issue in the resident, and I guess he had a pacemaker, and so they know that like the last event was on February 17th for him, and so they have like a pretty conclusive time of death for him. And go ahead.
Yeah, last I heard, yesterday I watched something, and they're trying to get into to their phones to see when the last messages or whatever took place.
Yeah, it's so bizarre that they're all, I think the dog was in a crate. So
No,
oh
the dog
no.
was they found the dog in a closet.
Oh, in the closet. I thought they found him in the closet in a crate.
Well,
But
that could be.
yeah. And so if she had passed away, the dog could have passed away simply because Hackman wasn't home and he got stuck in the crate, you know?
I think they found them all three at the house.
No, they found them all three at the house, but her body was much more advanced in decomposition. I think she was home while he was away. The way I'm understanding it is that their deaths occurred at different time points, because she was mummified. And that is, yeah. So that is like, so he may have been away, came home, and whatever it is, that it's going to be interesting to see how this works out. That's what has anyone else?
I haven't heard she was mummified. I hadn't heard that at
Yeah,
all.
let me see if I can see where it says that. I don't think he was home, because it looks like he died in the entryway kind of area. She was upstairs and the dog was in the closet. Let me see. Hold on.
I know they're looking at toxicology,
Mm-hmm.
trying to get into their electronic devices and so forth. With all that being said, Gene Hackman is definitely one of my top 3 actors' favorites of all time.
Oh, for sure. Who's the other two? I'm curious.
That's hard to really drive down, but honestly, Clint Eastwood is probably my favorite actor of all time.
Mm-hmm.
Number 2, there's so many that I could fit in that spot. But purely from probably an entertainment standpoint, there are other ones that are probably more qualified, but this from a purely entertainment and well, just many other factors. Probably Arnold Schwarzenegger. I really like the action movies. They're just silly stuff. But man, Terminator. I mean, Terminator was a kind of a thing, but it really blew up over the course of it went to video, and it just blew up. And of course, then we got Terminator 2 and that whole franchise that he's been a part of, and so many other movies. I mean, there are a lot of people I could fit into the number 2 spot. That number one, Clint, because that guy's not only a consummate actor, he's just a fantastic director, producer,
Mm-hmm.
music writer. Just given pretty much everything to that industry. It's made him very wealthy, of course, but he's given a lot back, a lot of entertainment. So, yeah, I really like Clint. Never forget watching The Good and the Bad and the Ugly the first time. Still one of my favorite movies. It's old.
Very good movie. Very good movie.
Yeah.
So I don't really have like a top. Christopher Walken, though, is one of especially his younger stuff. I did not realize
The Dead Zone.
Yeah, or Taxi Driver. No, that's Robert De Niro. The Deer Hunter is what I meant to say. That movie, I probably didn't see that until 15, 20 years ago. And I think it came out in the 70s. Phenomenal movie.
Yeah.
Really, really good movie. And so I like Christopher Walken. I also like Robert De Niro.
Absolutely.
Yeah. Heat.
So many great ones out there.
Yeah. Heat's probably one of my favorite movies. And which that's kind of not a lot of people have seen that, which is crazy to me. And I'll tell you someone else I really like that is, kind of is Christian Slater. Is that his name? Christian?
Yeah. Christian
Yeah.
Slater. Yeah.
There's a movie called True Romance, and it was actually directed by Tarantino. And Brad Pitt has a small role in it. And that movie is probably one of like my top 5 movies. And many people don't even know it's out there. But if you go and watch it, I'm just going to say, you're so cool. You're so cool. And you'll know why I'm saying that if you've seen the movie or you watch it.
Hey,
Murder.
Travis.
Oh, yeah, go ahead.
I was going to say Travis has listed the charges for us for Karen Reed: murder in second degree. Number 2, manslaughter while operating while intoxicated. Number 2A, lesser included, involuntary manslaughter. 2B, MV homicide negative while under the influence over a .08. And number 3, leaving the scene of a accident resulting in death.
I got a question.
Yeah.
How can you charge someone with 3 different types of murder type charges, right?
Given the jury choices based on what evidence is presented, I guess.
So can they convict her of all 3?
That I don't think so.
Because that's what I find interesting.
I don't think so, because if they choose one, they would have to vote no on the other.
Yeah.
Couldn't be all 3. No, they'd have to pick one or the other.
And that's probably where the judge screwed up on her jury instructions, right?
Well, she didn't tell them. She told them to not fill them out until they reached a decision on all of them, which is incorrect. Because they're deciding each one on its own merits. That's what they should be doing, I would think, right? So if they come to a decision, it's murder in the second degree. It's not guilty, and you're done. That one's done. So,
and then you can't recharge her. But if you leave it blank, then it's open for interpretation, which seems kind of slimy to me.
Yeah.
But what do I know? So it says that, and this is regarding the Hackman death. It says that she was found and the body decomp floating in her face and mummification in her hands and feet.
Okay.
So what does that mean? I don't know. But it's clear that it had been quite some time. And
they're saying they're saying at least 2 weeks. That's what I heard.
Yep. And it's going to be interesting. I was thinking someone could have been in their house.
Well, that's what I thought too, but they're not saying that there's signs of foul play. But with all 3, the 2 humans and the pet being, she was 30 years younger than Hackman. He was 65. He was 95.
I can't believe he was 95. That's crazy.
A lot of people don't know this, but I read this in a story, and then I promise we'll get onto this document. I read a story. This has been a few years ago about Hackman. He was in some kind of store wherever they live at, a large type store, and kind of like a Sam's or whatever, that large type building.
Like a Costco. Something like that.
But whatever. Anyway, this light fixture that was hooked above fell and hit him and hurt him. And of course, he was okay. He survived and all that, healed up. But his lawyer, I guess his lawyers or investigators, come to find out that these light fixtures, the whatever bracketing that they used, there had been other failures in other places too. and so he took a lawsuit on them.
Uh-huh.
Yeah, and won.
Of
And
course.
they were also forced to change that bracketing. I had no idea. You know, it really upset me when he retired from acting because he's so good.
Yeah.
He's just such a great actor.
Well, if he's 95, I think Clint Eastwood still alive too, right?
Yeah, he's
Yeah.
94. I think he's
Yeah.
94.
I was
Yeah.
going to say he's in his 90s as well. Another
Yeah.
great actor who's underrated or not underrated now, but I really enjoyed his younger stuff, is Morgan Freeman.
Oh yeah, Morgan. Oh yeah, he's a consummate actor as well.
He played in well, of course, he played in The Green Mile, if I recall correctly, or the other one. What was the other one?
He played
Shawshank.
in Shawshank and in Seven with
Mm-hmm.
Brad Pitt, I think it was. It was a great movie.
Yes.
But he's been in a bunch of movies too. So
But
there's so many.
he played in a movie, I believe it's Robert Redford, called Brubaker. Is that the prison movie that was in the 70s?
I don't think I saw that.
If you haven't seen it, Jax, you'll like that movie. I didn't watch it until probably 15 years ago. And it's a prison movie. Very similar to Shawshank in ways, but not. And Robert Redford, let me make sure. I think it's Brubaker.
Another great actor as well. But there's so many. What's that?
It is. It's Brubaker. And
Okay.
It was filmed in 1980, and it's really good.
I'll try to catch it.
Mm-hmm.
Danny Bruce fan says FBI almost screwed up the Brian Koberger case. You know, that's another one that's upcoming. I haven't seen anything much posted. I know I found a clip of something not too long ago when I put it in his room on Discord. So we'll see how that flies. Anyway, yeah. Anyway, let's get over to the document.
That's going to be an interesting case.
Koberger?
Yeah.
Oh yeah. Oh yeah. Yeah, I mean, you know, if what they found is true, that knife sheath with his DNA on it, I don't know how he can get out of it. I just don't. And I don't want to prejudge someone, right? It's hard, but when you see that or you hear that, it's like, okay, well, what the hell is your knife sheath doing in there? These gals and you know, people are cut to ribbons. How did that get in there? They found your car, what they know was nearby on King Road there. He's going to have a tough road. I'll be interested to see what kind of defense they put up. I really will.
Well, hold on a second.
Yeah.
So they found his DNA on his knife sheath.
Yep. It got left behind, apparently.
Well, or it got brought there. See, I got a problem with easily transportable evidence being the link. I need DNA in the house on like walls. Stephen Avery case has really made me question.
It's possible.
You know what I mean?
You're not wrong. You're not wrong.
It is not, that to me is not enough. You're going to have some evidence of him being at that scene besides a piece of evidence that's easily placed or moved there. That to me does not concretely prove a crime was committed.
Yeah, but what will a jury think?
Yeah,
and then tied in with them tracking him very close to the house on that night, yada yada yada.
Yeah, well,
we'll see.
We'll see. Exactly. We'll see.
I'm
I
looking forward to seeing what they present.
Yeah, that's going to be a really interesting case.
Yeah. All right. Let's move on to this document,
Okay.
which is going to make me throw up. And I promise, as we're reading this, I'm going to try my best not to interrupt and stop when I get cranked at a particular sentence. I may try to finish the paragraph and then do my deal. But of course, anyone in the that's listening, if you have something that we read that you have a problem with, whatever, just put a Q in front of it. I promise I'll try my best to go back and forth and catch these questions if you have any, of course. I mean, this is not new, but we haven't read this. This was August of 2023, as you all can see, and of course, this led to the Court of Appeals appeal that Zellner filed, which leads us to where we are now with them denying. So, and interestingly enough, and I don't remember the date, but it wasn't very long after this that Suckowitz
Hit
dropped
the
the
road.
case.
Yeah.
She dropped it after, let's see, 2023. So I'm going to say 11 years, 12 years she had been on Avery's case, both criminal and the civil part. I don't understand. I just don't. She knows.
How was
the
she able to do that?
As I recall, that there was an excuse put out because of her caseload. But to me, you would offload the new cases to the new judge. You wouldn't just take
Yeah.
something that she's familiar with. But to me, I think the personal opinion, of course, only that this is so bad that she was taken off the case. That's what I think. But I can't prove that, of course. Anyway, let's move on and get through this. I hope people have Pepto or whatever settles your stomach, and maybe an appointment with your therapist. I don't want to blow this up too big, but make it big enough here that's viewable because this type is pretty small. Where you at here? There we go. Well, that's not what I wanted at all. Okay, let me try this. Trying to get this big enough where it fills the screen part of the way.
I can see that pretty well.
Yeah, I'm trying to get it centered here. Okay, there we go.
Yep.
All right. So we'll do kind of what we did last night. We'll just trade back and forth. Is that okay with you?
Mm-hmm.
Okay. All right, I'll start us off here, and I'm going to read the footnotes. Whatever we run across, I can't remember how many there are in this one. So anyway, memorandum of decision order. The defendant is back before the circuit court with a post-conviction motion pursuant to Wisconsin statute 97406 through his attorneys Zellner and Associates. The defendant asserts that newly discovered witness statements will establish that there is a viable third-party suspect for this offense. The defendant asserts that evidence regarding this third-party suspect was never presented at the time of trial, and the failure of the presentation of the alternative suspect undermines the confidence in the jury verdict. The defendant further asserts that the state violated the provisions of Brady v. Maryland. If the court rules that the third-party suspect evidence does not meet the requirements to grant relief pursuant to his request for post-conviction relief, the defendant asks that alternatively that the court grant him a new trial in the interest of justice pursuant to Wisconsin statute 805.15. Facts. The court will not recount the full record in this voluminous case. The facts have been set forth in numerous filings in prior court proceedings. This court will, refer only to the facts alleged in the current motion before the court. Prior to the commencement of this trial in 2006, the trial court entered an order requiring the defense to identify any individuals, quote, other than Brendan Dassey, end quote, that it intended to suggest was a third party responsible for any of the crimes charged against the defendant. Furthermore, the court stated that the admissibility of evidence regarding the potential third party suspect would be required to meet all the standards set forth in the ruling in State v. Denny. The defendant provided notice that he would assert that there was a reasonable possibility that others committed the murder with which he was charged, including Scott Taddick, Andres Martinez, Robert Fabian, Charles and Earl Avery, and the Dassey brothers. In addition, the defendant argued that the ruling in Denny did not apply to his trial and that if it did, he should be permitted to present evidence regarding several alternative suspects. Okay, Christina, you want to read a couple pages? Oh, she stepped away. The trial court found that the standards set forth in Denny did apply to the defendant's evidentiary offering and noted that in the absence of motive, it could be more difficult to offer evidence that would be relevant and material to a third party or to a third person having committed the crime. The court concluded that nothing in the defendant's offer went beyond the level of speculation. The court stated that while the defendant identified many people with the opportunity to commit the murder, no clear motive for the crime was identified for any of the alternative suspects failing to meet the Denny standard. And, just to add to that, if you seek a Denny ruling, the defendant has to provide motive, whereas in a criminal trial, the prosecution does not.
Which
I don't agree with
it. Yeah, so whack-a-mole.
Yeah, it is. Okay.
After, you want me to?
Yeah, go ahead. Yep.
Okay.
Yeah, go ahead.
After the defendant was convicted of this murder, he filed a post-conviction motion pursuant to Wisconsin Statute 974.06. The court concluded that while the defendant may have supplied evidence as to motive to frame the defendant, none of the evidence identified a motive. Hold on, I lost my spot. None of the evidence identified a motive for Bobby Dassey to murder Teresa Halbach. Without establishing any evidence of motive, the court concluded that Mr. Dassey was precluded from being named as a potential suspect under Denny. The Wisconsin Supreme Court allowed the decision to stand. Shocker. Several other post-conviction motions were filed, denied, and upheld by the appellate courts. The Court of Appeals ruled on the defendant's last post-conviction motion on July 28, 2021, upholding the circuit court's decision. The court found that the content of the defendant's motion was insufficient to entitle him to a hearing on his claims. While that motion was pending before the Court of Appeals, the defendant requested that the court stay its decision and remand the matter back to the circuit court for evaluation of a new claim. The Court of Appeals noted that the defendant was asserting a Brady violation involving the affidavit of a new witness, Thomas Sawinski. In his affidavit, Mr. Sawinski asserted that he saw Bobby Dassey in possession of the victim's vehicle several days after the murder. Mr. Sawinski stated that he called the Manitowoc Sheriff's Department later that day to report what he saw and was dismissed by the deputy. In its decision of July 2021, the Court of Appeals stated that the defendant's newest claims regarding a Brady violation had little or no relation to the claims before the court in that appeal. The court stated that this issue should be resolved in a separate post-conviction before the circuit court. The court further stated that, as discussed below, we are not addressing Avery's most recent filing to this court. See our discussion of motion number 6, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new 974-06 motion. That motion would need to survive both Escalona Naranjo scrutiny and be found to have merit, in which case the evidence presented might supply the missing direct connection. In that event, the Veely CD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such 974-06 motion, as all such issues would be for the circuit court to decide in the first instance.
Yeah, that's interesting there.
It's very interesting.
Well, this is the direction that they gave her. This was the only option coming from the Court of Appeals.
Mm-hmm.
So I did want to, we'll come back to this. This part right here, Mr. Sawinski stated that he called the Manitowoc Sheriff's Department to report what he saw and was dismissed by the deputy.
Yeah.
And he's got to be talking about Singlove. He's got to be, because that's who he talked to.
Mm-hmm.
I'd really like to have that conversation.
Yeah.
I'd really like to have it.
Well, and it's interesting that she is not, when this was filed, did Zellner include a copy of the call? Has it been entered into the conviction record?
No, it had not, because we didn't have it.
You see, and that's another, to me, that's frustrating, because
it's Brady.
I really think that would bolster this brief, to have
Absolutely.
the evidence that this witness, who, yes, it may be 20 years later, we have evidence showing that
he called.
Yeah, that he called.
Well, I think that, if my memory serves, it came during the decision when she had it. And so I think it had to be whatever, I can't remember. It had to be supplemented or whatever to be entered.
And that's it's almost like it's intentional. They give us the call so we can find the call after.
Wait a minute. It was entered. We did have the call. We did have it. No. Let me take that back, because this is August of 23. We got the calls early 2022. I'll have to check on that, Christina.
Yeah,
I'm going to say that
it's all going to be right around the time.
Well,
like those calls were given to Rookie right around when Zellner was filing these motions.
I think if memory serves, it had to be supplemented or added or whatever the legal process is to add the call in, because it was after she had submitted her brief. I'm pretty sure that's right. Don't hold me to that. She
was able to get it in, and the judge isn't even acknowledging that there's not only did he call, And I feel like a unbiased judge would at least acknowledge proof of the call exists, right?
And it being withheld. And it being withheld.
And yeah, and there was no follow-up done or whatever, right? I mean,
Right.
I know that they're always going to be pro-state because that's just, that's just the way the cookie crumbles. But
Well, it is now. It is now. It used to wasn't this way. Judges were not all, of course, but a good chunk of judges weren't. They wouldn't take any shit off either side. They just wouldn't do it. They'd hold their feet to the fire and light the match, and that would go along with any law enforcement agency that was being playing not by the rules, playing by their own rules. Things changed. They started changing in the 90s, and not for the better. Not for the better. So anyway, yeah. So if you want to continue, read a little bit more, you want me to start?
You can start.
Okay. Well, this what Christina just read is referring to the state v. Escalona Naranjo. As a result of this ruling, the defendant brought this post-conviction motion pursuant to 406. The defendant asserts that by failing to disclose the statements of Mr. Sawinski to the defendant, the state withheld exculpatory evidence from the defense in violation of the Brady rule. And they did. Furthermore, the defendant states that the evidence supplied by Mr. Sawinski creates a direct link between Bobby Dassey and the murder of the victim. As such, the defendant asserts that he was denied the opportunity to present evidence of a viable third-party suspect at his trial. By denying the defendant the opportunity to present that defense at his criminal trial, he argues that the issues in the case were not fully tried and that had the jury been presented with this testimony, the verdict in the case would likely have been different. The defendant is now asking the court to review the aforementioned claims and grant the defense relief, or in the alternative, grant him a new trial in the interest of justice. Analysis. For the affidavit of Mr. Sawinski to be admitted as evidence establishing Bobby Dassey as a valid third-party suspect in the murder of Ms. Halbach, the defendant must satisfy two separate tests. The test in the Denny Supra requires the defendant show that the third party had a legitimate tendency to commit the crime at issue. To meet this burden, the defendant must show that the third party had a motive to commit the crime, the opportunity to commit the crime, and that there is some direct evidence linking that party to the crime that is not remote in time, place, or circumstance. The defendant also raises and correctly identifies that the test set forth in State v. Edmonds also applies to the admissibility of the affidavit itself. The Edmonds court established a four-part test to determine if evidence is newly discovered and admissible for consideration by the court. First, the evidence must have been discovered after the defendant's conviction. Second, the defendant must establish that he was not negligent in seeking out the evidence in question. Third, the defendant must establish that the evidence is material to an issue in the case. Fourth and finally, the defendant must prove that the evidence offered is not merely cumulative to that already in the court record. The defendant further notes that only if the four requirements are met is the circuit court required to determine whether a reasonable probability exists that a different result would be reached in a new trial. State v. Lowe. In his affidavit, Mr. Sawinski states that in the early morning of November 5, 2005, he was delivering newspapers to a salvage yard in the course of his employment. Prior to actually delivering the newspapers, Mr. Sawinski states that he encountered Bobby Dassey and an older unidentified man pushing a dark blue RAV4 down Avery Road toward the junkyard. Mr. Sawinski stated that the car did not have its lights on. After delivering the newspapers to the Avery mailboxes, Mr. Sawinski states that he drove back towards the exit to where Bobby, the older gentleman, and the car still were. Mr. Sawinski states that Bobby then stepped in front of his vehicle in an attempt to stop him from leaving the property. He further states that his headlights were shining directly on Mr. Dassey at this point.
Can we pause for a second?
Sure.
I think if you take that statement, scroll back up 2 sentences.
Okay.
All right. Now, we both know that I am of the belief that it was likely, law enforcement that moved the car on the property. All right. That's just my thinking. And it says that Mr. Sawinski states that he drove back towards the exit where Bobby, the older gentleman, and the car still were. Mr. Sawinski states that a teenage boy is not going to step in front of his vehicle and try and halt him. But you know who would? Someone who's a cop. Because they are comfortable thinking they have the ability to do that. So if it was a cop, if it was two people connected to law enforcement, and they wanted to get him, corral him and get him not thinking what he saw was what he saw, they would not think twice about trying to flag him down and explain what they were witnessing. A teenage boy wouldn't do that.
Well, I wouldn't,
Do you
do you
understand why I'm saying that?
I had issues with it when I read it the first time. I mean, not like major issues, but it doesn't sound normal for most people to have stepped in front. I mean, depending on how fast the car's going, if they're just, crawling, not going that fast, then that's no big deal. But if they're doing 10, 20 miles an hour, I'm probably not going to step in front of it.
No, not unless I think that I have the ability to get them to stop.
Yeah.
And the fact that, and it's I can't remember like the layout enough to say, is it a dirt road that he would have been driving on, or is that road paved, or was that road paved then?
Well, I think it was gravel, but it had a lot of, potholes and so forth.
Yeah,
just from rain
so he wouldn't have been going super fast. Plus, he was, he knows that he's going to encounter them on the way out because he encountered them on the way in. So he's going to be mindful of that. Because, you're not like on a 4-lane road or whatever where the speed limit's 55. But I know people have issue if it isn't Bobby that he saw, why is she putting Bobby's name in there? And my belief is that you have to use what you have to get the case reopened. And then Bobby is also the person who has Teresa never leaving the property, right?
Yep.
And in reality, he saw her leave. They had him lie first to get her to stay on the property, which allowed them then to have the crime occurring at the property. Because I am of the belief that the crime that they were going to use to convict him was not going to occur on the property until they knew that there was too much evidence showing that Stephen could not have left the property for the time needed for the crime to occur. So they had to move the crime onto the property. And and if any of that is true, then we know that you can't trust anything in this case, which is why.
Well, we get to the story of the key, and that a lot of their integrity for me fell apart. When
Yeah.
we really found out, when we got the court documents and we really found out the full gamut of what they said happened, it's like, wait a minute now, hold up. Anyway,
Yeah. I mean,
question,
well,
question.
it's like that with every piece of evidence. We talked about that last night. But it's
Sure.
just very interesting that he says that Bobby tried to stop him from leaving. That's something a cop would do.
I don't, personally, I don't, I just don't believe Bobby is involved, but that's me. And I
Me
know that,
either.
I know everybody doesn't agree with that. Some people believe Bobby and whoever was involved in at least moving the vehicle, you know, over that road can travel, but I don't necessarily believe that. Anyway, Doc has a question. Who did Ramlo inform about seeing the RAV4 at the turnaround? And he saw a cop in a Civic station. There was discussion for a long time that it was Colburn, but Colburn was allegedly off that day. But there is another officer, and I can't remember his name, that could really, somebody could possibly mistake him as Colburn. And if you only seen him one time and saw Colburn later. So anyway, allegedly it was Colburn, but there's another cop, MTSO cop, that it also could have been as well.
But just because he's off doesn't mean he wasn't wearing his sheriff's jacket. Doesn't mean he wasn't going to the Civic station. You know what I mean? And just because he wasn't on duty doesn't mean he wasn't still an officer. It just means he wasn't working.
That's right.
Paid for it. But
well, and we know that. I mean, just based on other statements that we've had in the years after. I mean, he's, unfortunately for Colburn, his credibility took a serious beating. Was some of the after the thing. I'm not necessarily saying during that particular time frame. I'm just saying. I'm just saying later. His reputation kind of took a beating, and then when he filed the lawsuit, the civil suit, oh my God, there was so many just outright lies. Whether he uttered the words or not, that's what was presented in his lawyer presented in the trial record. His divorce was blamed on making a murder, and it wasn't true at all. It wasn't even close to being true. It was
Ken
liar.
Kratz blamed making a murderer too for all his mess ups.
All his problems, yeah, of course.
It worked for Kratz. Colburn figured, well, hey, why not? It might work for me.
That's right. Okay.
It's all Steven's fault. Poor guy.
Right. Well, now it's all foul play's fault. We're responsible for the Black Death and the plague and COVID and sunspots. Everything's our fault. So,
wow.
Just want you to keep that in mind. Anyway, let's continue.
Yeah. Hold on one second.
I'll reread that sentence. He further states that his headlights were shining directly on Mr. Dassey at this point. Mr. Sawinski then states that he came within 5 feet of Bobby Dassey, who looked unhappy to see him on the road, and he was forced to swerve into a ditch to avoid him. Fearing for his safety, Mr. Sawinski called out, quote unquote, "Paper boy, gotta go," and drove toward the exit. After learning that Miss Halbach's car was found on the property, Mr. Sawinski states that he realized the importance of what he had seen and immediately contacted the Manitowoc County Sheriff's Department to report the encounter. Now, just to be clear before I continue reading, just to be clear, this was the early morning hours of November 5. Now, I have no idea what he did that day. Of course, it all blew up on the morning of the 5th. It just exploded from a media standpoint. But Sawinski called around 10:30 p.m. on the night of November 6th. So it wasn't long. Maybe he hadn't. I mean, he carries the newspaper. One would think you would know, but it's kind of like, somebody that like a milk truck driver. They're not necessarily going to sample all the milk. You know, they carry the paper and deliver it, but not necessarily read it. So I can't say that his timing is that screwed
Well,
up.
he
I
called. No,
can't.
he called when Stephen got arrested.
No, no. He called the night of November 6th. Avery wasn't arrested till the 9th.
Oh, you're saying he called the next day?
That's right.
Oh, so that's not long.
No, it's not. Not long at all.
No.
But he's saying that the officer, whoever he talked to, dismissed him. Again, I would give real money to have the contents of that conversation. I mean, like
Yeah.
real money. But it's lost anyway.
Well, they say it's lost, but they also said they didn't have the calls that we got.
Well, that one,
he's called, right?
that one I can believe is gone because just of the way the phones work. I just think that once the new connection was made, the recording is stopped.
Oh.
Yeah. So anyway, yeah. He calls to report the encounter. Mr. Sawinski then states that after viewing a television show, Ma'am Making Murder, he contacted the Innocence Project in New York to report the incident again.
Wow.
Finally, in 2020, Mr. Sawinski contacted the defendant's current counsel, and the current affidavit was drafted. Okay, you want to read a little?
Yep, I'll read it. With respect to the first requirement of the Edmonds test, the defendant states that Mr. Sawinski did not come forward and contact the defendant's counsel until April of 2021. In his corrected affidavit, Mr. Sawinski states that he originally believed that he contacted the defendant's counsel in 2016. However, it was later discovered that Mr. Sawinski actually sent his communication to the Innocence Project in New York. Counsel states that this information was not relayed to the current defense team at that time. The defendant asserts that in spite of numerous discovery requests filed by his original trial counsel, the record of the call that Mr. Sawinski made to the Manitowoc Sheriff's Department was not turned over to them until after Mr. Sawinski came forward in 2021, and an additional specific discovery request was made. If that doesn't sound like Brady.
Yeah. Here's a footnote. Let's look at it.
All right. So footnote 1 is there is mention in the defendant's filing that the first phone call came to the defense team in December 2020. Both dates clearly come after the date of Mr. Avery's conviction. The second footnote is the state's objections to this evidence goes to the defendant's argument asserting a Brady violation occurred earlier in the prosecution of this case. The state's argument will be addressed in that analysis.
There you go.
This is a clear Brady violation. Like, if she can get all of the evidence and show that, because see, I think she also needs to do the fact that the detective that he spoke to didn't file a report, and then that Wisconsin DCI agents and Calumet agents went around the Avery property and interviewed neighbors asking questions about the mail and newspaper delivery times, but never explained why they did so. Like, what does that have to do with it? Like, you know what I mean? That is like a CYA move to me, to try and create a narrative if so needed.
Right.
Yeah. Like, if he was able to get a hold of Buting and Strang and they were able to get him in front of the jury, they wanted to be able to have an avenue to try and discredit him. Do you see what I'm saying?
Absolutely.
Yeah. Yeah, I agree. And that to me is very telling of what he witnessed, and kind of for me gives weight to his claim of seeing something. Is it?
I definitely think he saw something.
Yep. And I think that he saw it, he called about it, and they chose to bury it and then try to, just in case, like, what if Laura and
Maura.
yeah, if Laura and Maura, if he'd ever been able to get in contact with them, and they were able to get with Buting and String and get, it's clear that they knew they had gotten caught, and they were trying to create a pathway to save that from being an issue.
Well, the real problem for me is the phone call.
Mm-hmm.
The number one, it was made and nothing was done. Sawinski wasn't interviewed at all. But what Singlub did or didn't do, we'll never truly know.
It would
what
be
his
nice. It would be
Yeah.
nice to know what he was doing. Have we done that? Like, to try
He was at the command center at the Avery Salvage Yard. I don't know why. He was the officer in charge basically for the evening up until whatever time he gets off. He was at the Avery Salvage Yard doing whatever at the command center when that call got forwarded to him. You can hear,
or on the 6th.
on the night of the 6th. Yeah, you can hear whichever dispatcher it was. You can hear her dial the and then of course it gets connected. And that's where the call cuts off. The call being withheld for all those years is a real telling point for me. It's a real problem. Whether the court sees that or not, other people are like, well, whatever. That's nothing. So withhold a few phone calls. But a phone call could, or something small, could absolutely break any case open that was unknown to the prior defense.
Mm-hmm.
They don't know about it. They can't argue it,
Mm-mm. Nope.
And then avoiding interviewing this guy all these years. Anyway, help me, Rhonda says, could the jury have been bought, each secretly pay off? I suppose that's possible, but that would have been a really difficult thing to do. Really difficult without someone in one of the families noticing, the extra dollars, whatever. We're talking about multiple, I think 14 individuals, because there was 12 and then two or three alternates. Richard Mueller was dismissed, got out, so they had to bring in someone else. Is it possible? Yeah, it's possible that it would have been extremely difficult to have pulled off and not got caught, in my opinion. Anyway, you want to continue after your footnote here where it says, for the purposes of
this test only, the court will conclude that the evidence in the Sawinski affidavit was discovered by the counsel after the defendant's conviction, satisfying the first requirement of the Edmonds test. The defendant next addresses the second standard of the Edmonds test. The defense asserts that it was not negligent in seeking out the evidence set forth in Mr. Sawinski's affidavit. Prior to Mr. Sawinski contacting his attorneys in 2021, the defense states that it had no way of knowing that such an account of events existed. The log of the call that Mr. Sawinski made to the Manitowoc County Sheriff's Department was not turned over to trial counsel in spite of numerous discovery requests. Neither trial nor appellate counsel was on notice that any such contact occurred. The record of the call was only delivered to current defense counsel after Mr. Sawinski contacted the team directly, and the team specifically requested records of any contacts between Mr. Sawinski and the Manitowoc County Sheriff's Department in order to verify the assertion made in the affidavit. Based on those facts, the defense has met the requirement and satisfied the second standard of the Edmonds test. 2 for 2. Hey, interesting. Yeah. You want to go? You want to read some?
Yeah. Yep. Okay. The third standard of the Edmonds requires that the defendant establish that the new evidence offered is material to an issue in the defendant's case. The evidence submitted as being material to the defendant's motion goes to this theory that a third person committed the crime for which the defendant was convicted of. For evidence to be admitted to establish that a third party committed a crime rather than the accused, the evidence must meet the test set forth in Denny Supra. For evidence to meet the Denny test, I lost my place. The Denny test, the evidence offered must show that there is a legitimate tendency that a third party committed the crime alleged.
Mm-hmm.
More specifically, the evidence must establish that the third party had the motive, the opportunity, and a direct connection to the commission of the crime itself. While the defendant does not have to prove the guilt of a third party at the level that would sustain a conviction, the evidence that simply affords a possible grounds of suspicion against a third party is not admissible. State v. Wilson. So she's going from Denny to Wilson now. The defendant asserts that the evidence in the Sawinski affidavit establishes a direct link between Bobby Dassey and the murder of the victim. By linking Bobby Dassey directly to the vehicle driven by the victim, the defendant asserts additional evidence previously discounted in this case may then be reconsidered by the court, further supporting his third-party suspect theory. The defendant argues that the previous excluded evidence includes a CD copy of the computer hard drive found in the Dassey home. The defendant argues that this CD, which contains searches of terms and subjects, including images of violent pornography, would establish a sexual motive for Bobby Dassey to have committed the murder. The defendant argues that the Sawinski affidavit also establishes that Bobby Dassey had the opportunity to not only to have committed the murder of Ms. Halbach, but also to plant evidence including the defendant's blood and DNA in the victim's RAV4. Further, the defense argues that Mr. Dassey's possession of the RAV4 also provided him access to the key for the victim's car found in the defendant's home, as well as the victim's electronics found in the burn barrel, along with the victim's remains. The defendant finally asserts that the information in the Sawinski affidavit could impeach the testimony that Bobby Dassey gave at trial, in which he stated that the victim never left the property and was last seen heading towards the defendant's trailer. With respect to the motive element of the Denny test, the defendant argues that the state clearly considered that sexual assault was a motive for the murder, as evidenced by the seizure of the family computer in the Dassey home. The defendant asserts that the evidence of Mr. Dassey's motive to commit murder was contained on the hard drive of that computer, which was copied onto a CD referred to as the Veely CD. The defendant cites the decision of the Court of Appeals in which the court stated that the content of the Veely CD may become relevant to the defendant's motion if the defendant can prove a direct connection between Mr. Dassey and the murder committed. The defendant then goes into a lengthy argument as to how the evidence found on the Dassey family computer establishes the motive for Mr. Dassey to have committed the murder of Ms. Halbach. The defendant asserts that searches for words and images found on the Dassey computer shows an obsession with violence and killing. The defendant further states that images deleted from the computer were pornographic in nature and depicted violent images of torture and mutilation of young females. The defendant then refers to the affidavit of Brad Dassey, the half brother of Bobby, who states that he had a conversation with Barbara Dassey, Bobby's mother, in which she stated that she hired someone to delete the files from the computer in question. The defendant hired an expert to examine the Dassey family computer. His expert, Mr. Hunt, states that he discovered 8 periods of time close to the date of the murder from which the files were missing and presumably deleted. The defendant then states that Special Agent Tom Fassbender examined the VCD and in his report described the media that he found on the found on the disc. Images of the victim and the defendant with a date of April 18, 2006. Images of nudity of both sexes, including pornography depicting bondage and possible torture and pain. He further stated that other images on the CD included those of pornography, including acts between humans and animals, images of young women, and injured and mutilated people. The defendant then asserts that the record contains sufficient evidence to prove that Bobby Dassey was the only member of the household at home during certain days and home when some of these searches were conducted. The defendant bases this conclusion on the self-reported routine schedules of all of the members of the Dassey family that would have kept them out of the house at the time the searches were conducted. Based on those routine search schedules, the defendant asserts that every other member of the family living in the Dassey house was excluded from conducting incriminating searches and that only Bobby could have researched these violent and pornographic images found on the family computer. The defendant asserts that he too must be eliminated as a person who conducted the searches because he had no access to the Dassey home and did not have the password to the computer. As further proof of that he could not have conducted the computer searches, the defendant notes that most of the violent pornographic images were discovered were accessed after he was taken into custody on November 9, 2005, and that Brendan Dassey, who also convicted of crimes related to this murder, was in the custody on March 1st, 2006, when more of the violent images were searched. The defendant further cites Bobby's testimony at his trial in which he stated he was home alone and asleep from 6:30 a.m. to 2:30 p.m. on October 31st, 2005. Because there were searches done on the Dassey family computer during these hours, the defendant asserts that the only conclusion that can be drawn is that Bobby conducted these searches. Okay, you want to read a couple pages?
Yes. The defendant also refers to documentation of an interview of Bobby taken on November 17, 2017, in which he stated that the family computer was located on a desk in the living room of the Dassey home at the time. Bobby further denied that the computer was ever located in his bedroom. However, crime scene photos taken on November 12, 2005 show the computer in that location. The defendant further cites in an affidavit taken on June 25, 2018, in which Bobby's brother Blaine stated that the family computer was located in Bobby's room and Bobby was the primary user. Based on that evidence, the defendant asserts that the violent pornographic images researched by Bobby were conducted sufficiently close in time and were sufficiently similar in manner to the murder to establish a motive for Bobby to have committed a crime. The defendant relies on Dressler McCautry for the proposition that for the proposition that other acts, evidence admitted as evidence, could be proof of a defendant's motive. intent and plan to murder the victim. The defendant quotes the Dressler decision in support of his claim. The fact that the defendant maintained a collection of videos and pictures depicting intentional violence is probative of the state's claim that he had an obsession with that subject. A person obsessed with violence is more likely to commit murder, and therefore the videos and photographs are relevant. Id at 914. Based on the Dressler ruling, the defendant asserts that the court should find that Bobby's obsession with violent pornographic images made him more likely to have committed murder, establishing his motive in this case. In further support of his assertions, the defendant cites the report of his expert, Dr. Ann Burgess. Dr. Burgess states in her affidavit that there is a well-established causal connection between pornography consumption and violent behaviors. The defendant further refers to an affidavit submitted in a prior motion submitted by former FBI agent Greg McCrary, in which he offered his opinion that searches for violent underage and child pornography combined with images and searches for dead bodies reflects comorbidity of sexual maybe it's supposed to be paraphernalia, but paraphilia, I don't know. Agent Greg, she messed up. Agent McCrary is what it should say, further concluded that Bobby was becoming obsessively deviant in his reviewing of violent pornography in the weeks before Miss Halbach's murder. The state disputes the conclusions drawn in the defendant's argument, asserting that the defendant is misrepresenting the facts of the case. The state argues that the defendant has fallen short of establishing that Bobby Dassey was, in fact, the person who conducted the computer searches in question, or that the searches conducted were probative or relevant to prove that anyone had a motive to commit murder in October of 2005.
Oops.
The state argues that once again, the defendant failed to establish that Bobby Dassey conducted any of the searches cited by the defendant. Referring back to a previous decision issued by the Court of Appeals, the state recounted the court's conclusion that the mere fact that Bobby could have been home alone when some of these searches were conducted was not conclusive evidence that he did, in fact, conduct the searches. Okay. The defendant, the court continued, cannot rely on the opinion of a computer expert or anyone else's speculation as to what Mr. Dassey's actual schedule was on any particular day in question, a fact which applies to other family members as well. The state notes that there are no citations to any facts of record establishing Mr. Dassey's whereabouts at the time the searches were conducted, or any evidence that conclusively establishes that no other person had access to the home or computer at the time in question. Furthermore, the state notes that the defendant provided no citations of record to specific images that would directly relate to the crime committed or identify how any of the images were relevant to any specific individual having motive to commit murder. Referring again to the Court of Appeals decision, the state notes that the court previously concluded that the existence of the searches during a time that Mr. Dassey was usually at home is not a fact that would establish conclusively that he was actually in the home at those times, let alone that he was the person using the computer or accessing these images. The state further disputes the defendant's conclusions that law enforcement considered pornography or sexual assault as a motive for the murder in this matter. The state notes that during any criminal investigation, law enforcement collects all potential evidence. That's such a lie. Law enforcement collects all potential evidence that could possibly be relevant to the case. Okay. That evidence is then analyzed for determination as to whether it has any bearing on the crime committed. The mere fact that the investigator seized the computer does not prove any theory of the case. The state asserts that any relevance assigned by the defendant to the seized computer is unsupported speculation. Wow. Wow.
Yep.
Oh, yeah. You can read some if you don't mind while
Okay.
I just sit here stupefied.
Yep. Okay. The state also argues that the images and terms found during the computer search and cited by the defendant as evidence of motive for murder are not similar to what actually occurred during the commission of the crime and are not relevant to proving motive for anyone, including Mr. Dassey. The state asserts that someone having conducted a search for terms like news, body, journal, and cement, which are very general and not specifically related to this crime, does not show that the searcher had a propensity to have committed this specific crime. The state notes that the defendant's own exhibits show that the majority of the searches for pornography and violent graphic images had no direct similarity to the manner in which this crime was committed. So it has to be a majority now. The state further points out that most of the searches referred to by the defense occurred on a weekend when anyone in the house could have access to the family computer, while other searches occurred after 3:45 p.m. on a weekday, when Blaine would have had access to the computer as well. Wonder where that came from. Additionally, the state points out that the defendant's timeline in which she asserts that Bobby was the only person who could have conducted the searches does not account for the time when Scott School District spring break took place. Between March 24, 2005 and March 30, 2005, Blaine, Brendan, or anyone invited over by the boys could have access to the computer. Between April 7, 2006 and April 18, 2006, Blaine had access to the computer as well. The state goes on to argue that of the 128 searches listed and relied upon by the defendant as evidenced by the motive, only 28 of those occurred during the time that it is alleged that only Bobby Dassey could have accessed the computer. Furthermore, of those searches, only 3 of those searches occurred prior to Miss Halbach's murder. You mean 3 that weren't deleted? Assuming for the purposes of this motion that those 3 searches were conducted by Bobby Dassey, the state argues that a mere 3 searches conducted prior to the murder, Miss Halbach failed to demonstrate that Mr. Dassey was a voracious consumer of violent pornography prior to the murder, thus failing to establish the theory of motive offered by the defendant. Addressing the defendant's citation of Dressler v. McCautry, the state argues that the defendant's reliance on this ruling is misplaced for a number of reasons. First, the state argues that the ruling in Dressler was made in a habeas corpus proceeding and is not binding in Wisconsin criminal law. Second, the state argues that the facts in the Dressler case present a vast departure from those in the case before the court. In Dressler, the male victim was murdered in an extremely specific manner that included binding, mutilation, and dismemberment, While investigating the crime, law enforcement searched the defendant's home and discovered many weapons and restraints along with pictures, magazines, and videos depicting similarly murdered and mutilated victims as well as um, that type of pornography. These items were offered at trial as other acts evidence in support of proving the defendant's intent, motive, and pain to assault and kill. I'm sorry, I read that wrong. Motive and plan to assault and kill the victim in a specific manner depicted in the images found in the defendant's possession. The state argues that the facts in the case at Barr and those in Dressler are substantially different. In Dressler, the state notes that there was no dispute that physical evidence belonged to the defendant and was his exclusive possession. In this manner, in this matter, the state argues that the defendant has not provided any facts to prove that Bobby Dassey was the person in possession of the pornography alleged to be the motive for the murder or had exclusive access to the computer. In addition, the pornographic images discovered in the Dressler case were very closely mirrored the evidence discovered at the crime scene itself. The state argues that the defendant neither submitted any images from the Dassey computer that show an individual who was shot, burned, nor any pornographic images that depicted acts with any similarity to the Halbach murder. Furthermore, the state argues that the search terms cited as evidence of motive for murder are general and do not specifically relate to the crime committed in this matter. Finally, the state notes that all of the violent images and pornography found on the Dressler case were in the exclusive possession of the perpetrator before the murder occurred. The media evidence in the Dressler, the state argues, showed a prior disposition to commit the crime and a great similarity to the actual crime at scene itself, because the evidence was in possession of the defendant prior to the crime having been committed. The state argues that it did in fact demonstrate a motive, plan, intent to commit the crime as alleged. In the case at Barr, the state points out that the vast majority of the computer evidence relied on by the defendant to prove Bobby Dassey's motive to kill was obtained during the searches and conducted after Miss Halbach's was murdered. State further states that the images and search results from the Dassey computer did not directly mirror them in the manner in which the victim was killed. Unlike the defendant and Dressler, the state notes that the evidence offered by the defendant as proof of a motive cannot be proved to have been obtained by or have been in the sole possession of Bobby Dassey. It is interesting, I will make this comment, that what did Uyghur say when they seized Dassey's or Avery's computer? What he expected to find? Doc knows what I'm talking about.
Mm-hmm.
Images of porn and violence and death and blah, blah, blah.
Mm-hmm.
Exactly what he said.
Yeah.
Again, I'm not accusing Bobby or anyone in the Dassey house for committing this crime, but the double standard here is night and day. They found nothing except for some self images of Avery and Jody on that computer. Found nothing else at all that was even closely related. No pornography or anything. But they found all this other on the Dassey computer, and it's irrelevant.
And I'll add to that, the images on the Dassey computer align with a bloody blunt object and the blood spatter in the back of Teresa's RAV, two things that were minimized or not discussed at all. Yet we know at some point they were there, right? And the violence that was depicted in the pornography kind of adheres to the that were found on the Dassey computer. if you think about the questions that were asked when they were trying to link a camera to this case, remember?
Yeah. Oh yeah.
Yeah, those images are a are aligned with what the questions being. It's just really interesting. It's
Oh
really
yeah.
interesting.
Well, you know, if you're talking about the Avery's camera that he had given to Jody,
I am.
yeah, you know that whole thing came up because of a rumor, and you know that this actually came up on X the other day. Somebody said something about, I don't remember who it was, said something about images found on the camera. They didn't find anything. Nothing. I mean, certainly nothing of relevance. And if they did, why don't we say if there's something of relevance, why weren't they presented in court? And you know, again, this was almost a year after this crime occurred that they even bothered to get the camera. It's
Well,
crazy.
I have hypothesized that there may indeed be photos, and they just couldn't get them on Steven's camera. And the date of the time of the photos or something, there's an issue. Um, they weren't able to link them to Steven, and so they kind of disappeared. Now, you know, that's like, I'm not saying there is or there isn't, but it's just interesting when you look at the questioning that was done and the links they went to, and then it was like a nothing burger. They spent a
Well,
lot of time, and then it never panned out, I guess would
well,
be a way to word it.
there's photos on that camera. I remember a few of them. A few were of a deer that Jody took that was out in the yard, and trying to think of what. Seeming like there's a photo of like of a view of the, you know, a little grassy area and you know the woods. I don't remember anything. There may have been more than that, but I'm not remembering. But I don't think there was a lot of pictures to begin with. But what this person would say, you see the photos that came off that camera. What photos of anything incriminating? For certainly,
Mm-hmm.
they would have certainly been used at trial if there was.
Yes.
Anyway, you want to read a little bit?
Yep. Where are we at?
Yep.
To the extent that the defendant's submission establishes anything, the state alleges that it demonstrates the defendant cannot meet the admissibility standards under State v. Sullivan. The court in Sullivan ruled that for other acts evidence to be admissible, the evidence must be submitted for a permissible purpose. It must be relevant, and that its probative value must not be outweighed by unfair prejudice. While motive is a permissible purpose for which evidence can be used, the state contends that the defendant has not established that the evidence he offers is relevant to this matter. The state notes that the Court of Appeals has rejected the argument that the images on the Dassey computer depicted any situations that were similar to the crime scene in the Halbach murder. What crime scene?
Yeah.
But I digress. The state argues that there is nothing about the evidence found on the communal family computer that is relevant as to proof of motive prior to the commission of the crime. The computer information was collected long after the murder. Nothing in the evidence submitted, the state asserts, makes it more or less likely that Bobby Dassey committed the murder as the defendant alleges. The state also argues that because there is a lack of similarity to the crime committed and that the searches were done after the crime was committed. Can I just pause to say this is why Brendan's conviction could not be overturned? Because without Brendan, they don't have a crime story.
No, they don't.
So
At all.
No. Brendan is utilized to.
He's a pawn. He's a pawn.
Yeah. He was needed to have a narrative of a crime. Because without Brendan, all they have is random pieces of evidence, and all of it is highly suspicious, and nothing speaks to a crime like an actual murder. It's just pieces of evidence showing up in random places. And if you think about where it all is, they've made this quote crime scene unquote massively large in size. If you take her vehicle where the tag was found, then you have the bullet fragment in the garage, and you have a key in the bedroom, and then you
got remains scattered all. Yeah, well, you have the camera, but you have remains scattered in 3 or 4 different other areas around the whole deal.
Yeah, like if you really think about it, they have made this crime scene massive in scope.
Yes.
And with the evidence. And that's why Brendan was needed.
Absolutely.
Because without Brendan, it looks like it was just all brought in by random people, which says to me, I'm a wow. I really never actually even put that, like if you were to draw a circle around where all the evidence was collected from, I mean, and they're supposed to do that with how many people on the property, and yet no one actually witnessed them doing anything but having a fire.
Right.
Mm-hmm.
Somebody's got to have.
All interesting.
Somebody's, it's fact. Somebody's got to have to do what was done to Teresa. You got to have fuel and a good supply of oxygen. You got to have time and privacy.
Mm-hmm.
For sure. You can't dismember of a body takes time, and you can't be in view of people walking around looking at car parts, or family or anyone just driving up. And what are you doing? Well, I'm cutting this up. Don't worry about it.
Yeah. And what's interesting is, the dismemberment isn't even, which we know occurred from Eisenberg's testimony and reports.
Absolutely.
Is not even mentioned by Brendan or brought up.
No, he does put the body in the fire hole.
Yeah.
And they know that's not true.
Yeah, we know that those bones were cut.
Yes.
For sure.
That's right.
And yet
other people are saying, "Oh, it was done with the shovel."
No,
those that's right. They're saw marks. Somebody used a hacksaw.
Yep. And they even have the size of the teeth. So there's no, using a shovel. I mean, could a person have used a shovel? I'm sure, but they also used a saw. And
with a shovel, you're not gonna. To me, you're gonna shatter instead of making a straight line cut. You're gonna shatter.
Yeah. Well, I was just thinking they may have used a shovel when they scooped the bones to put them in Stephen's burn pit.
Yeah.
But so a shovel could have been used in this crime, but we know for a fact that a saw was.
Absolutely. There's no doubt about it.
The ME or whatever she is, the anthropologist talked about it. And I think Jensen, one of the MEs, I can't remember their names off at the moment. One of them discussed it.
Kleiser, Jensen.
Oh, it
was Jensen. Yeah.
Okay. Yeah. Oh, and the FBI. The FBI also discussed it in their tool mark analysis, those serrated saw marks.
Yeah.
So, but yet that was never, and it's interesting they never questioned Brendan about it.
That's well, how'd you get I can't remember the exact wording. How'd you get her out there and we'll throw in the fire, throw in their hole intact?
Mm-hmm. Yeah.
No, you didn't.
No. Very
Anyway.
interesting. The state also argues that because there is a lack of similarity to the crime committed and that the searches were done after the crime was committed, the prejudicial value of the evidence offered outweighs its probative value. Because there is no direct link to motive or any evidentiary similarity between the computer evidence and the crime committed, the state argues that a jury could convict Bobby Dassey on legally inadmissible evidence. If such evidence were submitted to the jury, the state argues that a jury could conclude that the individual who searched for such images was inherently a bad person and convict on that basis alone rather than on the applicable law. Oh, let's not prejudice the jury. Never.
No.
Wow. Gag me with a spoon. A review of the record and the defendant's argument reveal that he has failed to satisfy the third standard of the Edmonds test, as well as the motive element of the Denny test. With respect to the Edmonds test, the defendant argued that the evidence offered was material to an issue in the case because it established that there was a viable third-party suspect that could have committed the murder of Ms. Halbach. And such evidence was never presented to the jury for consideration, undermining confidence in the verdict reached. In order to meet that burden, the defendant had to prove that the evidence also met the standards set forth in Denny to be admissible as proof of a third-party suspect. The defendant failed to establish that Bobby Dassey had the requisite motive to commit the murder of Ms. Halbach. The defendant rests his motive arguments on the promise that Bobby Dassey had an obsession with violent sexual pornography involving young women and a fascination with gruesome homicides and deaths. However, the defendant's arguments are not supported by the evidence submitted. As the Court of Appeals has already concluded, the defendant did not establish that it was Bobby Dassey who conducted the searches in question. The Court of Appeals ruled that even if the defendant is correct as to what the usual schedules of the Dassey family members were, those general schedules are not proof establishing where any specific member of the family was on any given day. While the defendant argues that nothing short of a recording of Bobby Dassey conducting the searches on the computer would satisfy the standard of proof demanded by the state, this assertion is not true. The defendant, it is. The defendant could have offered any piece of evidence that during the time in question, Mr. Dassey entered some type of identifier unique to him, such as a specific username or a password. He can't offer it if it isn't there.
Yeah.
You know what I mean? So
it's a single password, at the time. It's not like now where you can have multiple users. Maybe if it was, I don't remember it, but I don't think it was.
And can we say if they would have got Bobby's, did we get Bobby's cell phone records?
Oh, yeah.
So were we able to see like his location during some of the searches?
That I can't remember. I just remember on the afternoon of the 31st,
Yeah.
he said he went one way, but the pings indicated that he was somewhere else
Yeah.
west of there. I remember that, but I can't. I don't know about. I don't know about the earlier in the day if his cell phone was on and was located at home.
Yeah.
I don't.
Or like on any of the searches because they pigeonholed and only focused on Stephen, if they're tying the defense's hands behind their back because you're saying we need to have hardcore evidence of where Bobby was and that it was him using the computer.
Got to have an identifier.
Yeah. Well, this is a post-conviction motion. This case, that's being made 15 years later with evidence that was crap to begin with. That was they never investigated anyone else with any true, investigating tools used. They made it look good on paper, but did they do cell tower locations of Bobby for, a week before and a week after? Did they pull all this data to try, which would have allowed her to try and put him at home? No, because they're not wanting Stephen to get out of prison. So anything that was helpful to the defense or could have been helpful to the defense, they're not going to do. And that's not investigating.
Or they did it and they withheld it.
Yeah. Yeah.
Yeah, I mean, the way she's wording this here, they're going to have absolute rock solid proof identifying a specific person. And I don't think that's the way the standard reads. The standard, I have to go back to the beginning of where she stated it, but it was a suspicion, someone that could be linked. And the first two tests was passed, but then now we're getting into the third and fourth parts, and she's going just so far out, saying you gotta have this, you gotta have this, dot, and just is very dismissive. I mean, very dismissive.
Yeah. All right. Let's see. The defendant could have offered any piece of evidence that during the time in question, Mr. Dassey entered some type of identifier unique to him, such as a specific username or password to establish that he was, in fact, the person using the computer to conduct the searches cited. The defendant could have offered a witness who saw Mr. Dassey actually conducting any of the searches in question. Wow. Even more simply, the defendant could have offered evidence that the defendant was actually home at the time of the searches, rather than speculation based on the typical schedules of the family to prove that Mr. Dassey conducted the searches. The Court of Appeals has already concluded that the mere fact that Mr. Dassey may have been home during the time that the searches were conducted was not conclusive proof that he was the person who actually conducted the searches that the defendant relies upon to prove motive for murder. The defendant's reliance on Dressler is also misplaced. The facts in Dressler were substantially different from those in the current case. The defendant in Dressler was shown to have very specific images in his possession that closely mirrored the evidence found at the crime scene. The instruments involved in the murder were found in the defendant's exclusive possession. The totality of the evidence proved that the defendant was in possession of the incriminating evidence prior to the commission of the crime. Do you know what? It just hit me. There was a 22 in the Dassey household.
Oh yeah. Oh yeah.
Same make and model.
And this is like the third time she's repeated the same thing that has been said before. This is the third iteration of the same thing she covered in Dressler talking earlier. I don't know why she's redid it. She's just piling on.
Yeah. Ad nauseum comes to mind, but yeah, no. But yeah, so we do have the type of bullet
and gun
in the Dassey household. So that's a link to the murder in itself. We have Bobby having access to Stephen's garage. So there's that, because they allege some of the crime was committed in Stephen's garage.
Well, and you have this too. It's a reminder of, under your scar says, and was said to be sold or tried. That was something that was looked into about Scott trying to sell this 22.
Mm-hmm. And and Bobby had access to Stephen's Green Dam, where his blood was, and his trailer. Yeah. So in this case, the images and terms searched by someone in the Dassey house on the family computer do not closely mirror either the method of murder or the disposal of the remains in this case. The searches offered by the defendant refer to generalized violent pornography and term searches. No search results offered by the defendant directly mirror the elements of the crime in this case. There is
does it have to directly mirror?
No, I wouldn't think so.
I mean, how tightly does it have to match a prior case before you can include this Dressler case, citing it as a connection? And to me, she's raised the bar so high that no one could reach it. Go ahead.
Yeah. Well, and I was just thinking, because we don't know, like I said, we only have Brendan's multiple different stories of the crime. We don't know what happened to Teresa from the time her last appointment to when the cremains were found. We don't really know how she died. We don't.
No, we don't. We don't know where the crime scene is. We don't know that.
All we have is the blood spatter in the back of her rab.
That's right.
That says that's her blood. And other than that, we have no crime scene. So we have no idea what truly happened to her.
No, we do not.
And so that being the case, it's hard to I don't even how can you say that these images don't in some way depict what she went through? Because we don't know.
We don't know.
And if she was being honest and and acknowledge that Brendan confession is clearly not what happened, she would admit that. But then he would meet one of the prongs.
Yeah.
And he's already met two. So can't do that. Can't do that. There is no evidence, only general assumptions that Bobby Dassey was the individual who conducted the searches on the family computer. The computer was not in the exclusive possession of Bobby Dassey prior to or after the murder. Only a very small number of searches were conducted prior to the murder of Miss Halbach. There's massive deletions of time. No physical evidence directly linking Brian Dassey to Brian. That's a typo, right?
Correct.
All right.
Bobby.
Okay, no physical evidence directly linking Dassey to the homicide was found in the house. The defendant offers the argument that Bobby Dassey had a predisposition to commit the crime based on an addiction to violent pornography. The defense offers two experts who discuss the role of pornography in the commission of this crime. Putting aside any questions as to the qualifications of the experts to opine in this matter, both of the conclusions reached by the experts depend on the assumption that Bobby Dassey was the individual researching the pornography on the computers, a fact not established in this matter. Furthermore, the experts reached their conclusions without doing any forensic or psychological examination of Bobby Dassey in person. Their conclusion as to his mental state are based on evidence that is not admissible in this case. The defendant has not met the burden under Denny to establish that Bobby Dassey had motive to commit the crime alleged, and as such, failed to meet the burden to admit the evidence offered to prove the existence of a third-party suspect for the commission of this crime. Without such a finding, the defendant cannot meet the third element of the Edmonds test, establishing that the evidence is material in his case. As previously noted, evidence that simply affords a possible ground of suspicion against a third party is not admissible. You want to take over?
I will.
Okay.
Even if the defendant had met the burden with respect to the motive element of the Denny test, he has not met the burden with respect to the element of opportunity under the same test. The defendant asserts that the legal term of opportunity is broad and encompasses other acts of evidence that may otherwise be inadmissible. Wilson. The defendant states that the opportunity can include the individual's physical presence at the crime scene or proof that an individual had the requisite skill, capacity, or ability to carry out an act. The defendant also notes that it is incumbent on the proponent of the evidence to show the relevance of the evidence offered. I don't know what that citation is. It says footnotes omitted. Okay. The defendant notes that Mr. Dassey was present at the Avery family property on the day that Ms. Halbach's murder took place. See, she's relying on October 31st anyway. The defendant then refers to the affidavit of Mr. Sawinski to further support his other arguments. The defendant argues that the affidavit of Mr. Sawinski establishes that because Bobby had possession of the RAV4, he therefore had access to evidence that the defendant asserts was planted to frame him. Specifically, the defendant asserts that Bobby's possession of the RAV4 gave him access to the key found in the defendant's home and the victim's personal electronics found in the burn barrel. The defendant further states that Mr. Dassey had access to his blood because on November 3, 2005, the defendant reopened a cut on his finger and dripped a substantial amount of blood in his bathroom sink and on the bathroom floor. The defendant then states that he went to the Dassey residence to ask Bobby and his brothers if they would like to go to Menards with him and his brother. According to the defendant, Bobby decided to stay behind. It was also at that time that the defendant states that Bobby saw the open cut on his hand. The defendant states that when he left for Menards, he left his trailer unlocked and upon leaving, saw the taillights of a vehicle near his trailer. The state agrees that in some instances, an individual can be implicated in a crime by their mere proximity to a crime scene. However, in the matter before the court, the state argues that the defendant is offering a much more complicated scenario as to Mr. Dassey's opportunity to commit the crime. Referring to the defendant's argument In order to satisfy the DNA test, the state asserts that the defendant must offer evidence that Mr. Dassey had the skills, contacts, tools, time, and/or other means necessary to have committed the crime and staged the scene in the manner alleged. The defendant must provide evidence that the third party had the realistic ability to engineer such a scenario. Wilson. The state argues that the defendant failed to meet that burden in this matter. The state asserts that the defendant has offered no evidence to establish that Bobby had the opportunity to successfully orchestrate this extremely complicated scheme to frame his uncle. The state argues that the complete absence of any necessary facts to support the defendant's argument demonstrates that the defendant has insufficient evidence to show that Bobby had the opportunity to kill Ms. Halbach and frame the defendant in the manner the defense claims. The state goes on to argue that the defendant has offered no evidence to establish that Bobby had the necessary skills available to manipulate the evidence in a manner that would implicate the defendant. The state notes that at the time of the murder, Bobby was an 18-year-old high school graduate with no criminal record. Mr. Dassey was employed as a third shift worker at a furniture factory. The state posits that there is no evidence of record that establishes how an individual of Bobby's age and experience would have obtained the scientific knowledge or skills to collect, transport, and plant the defendant's blood from his bathroom. The state notes that nothing in the record indicates to show how Mr. Dassey would have obtained the necessary materials to collect and transfer evidence in a manner successfully, as well as in a manner not detected after analysis by the crime lab. The state points out that the defendant, in his brief in chief, does not address how Bobby transferred touch DNA to the victim's car. The footnote for that. Footnote 3. In his response brief, the defendant asserts that he previously explained that the touch DNA was transferred by law enforcement from an illegally obtained swab of his person. However, the defendant also speculates that Bobby could have taken his toothbrush from the bathroom and used the DNA from that to place the DNA on the victim's car. This new claim, the defendant has not previously mentioned a missing toothbrush in his previous motions or attributed such action to Bobby Dassey. It is not clear from the defendant's argument which scenario the defendant is now relying upon. That both Bobby Dassey and law enforcement independently attempted to frame the defendant, or that he is abandoning his new theory of law enforcement involvement in the planting of the evidence, and speculating on the theory that the toothbrush provided the touch DNA on the car. Interesting. Go back up. Who the hell was that? Right there it is. Furthermore, the state notes that the defendant does not explain how Bobby could have kidnapped and killed Miss Halbach and then hit her body and her car within minutes of being seen on the highway at approximately 3 p.m. Referring to the record, the state asserts that it contains no explanation or evidence to establish how an individual with Bobby's age, education, and experience discovered a tiny mangled bullet fragment that he knew had the victim's DNA on it and planted it in the garage, or alternatively shot the victim there on the 31st and managed to thoroughly clean up the scene without the defendant noticing. Bobby, even though he was using the garage to work on vehicles during and after that time. The state additionally argues that there is nothing in the record explaining or supporting the theory that Bobby moved the victim's body and burned it at some undisclosed location, then moved the bone fragments from almost every bone in the human body back to the burn pit.
Oh
on
my
the
God.
Avery property undetected. While it's that's so irritating because she's trying to make it like that he moved an entire skeleton back there, and it's just not true at all. And
No.
virtually none of the torso was found, so there's very little of that.
Well, let's be frank here. Barely anything was found. If you really want to like sum up what they have are boxes of stuff, but in reality they have very few fragments they were able to say were human. And the largest, I think, is item BZ, if I remember, which is
Right. That's right.
Which was anywhere
Kitty,
from the size of a golf ball. And then, but when you actually look at it, it's not even that big.
a couple inches long, a little over, I think.
Yeah. And most of it is half like size of fingernail fragments. And so you're talking about it's almost it's like, yeah. And the other thing that's so frustrating is every single piece of the evidence that she's making seem like it is, damning and how could Bobby have done anything with it? It all has issues in the crime lab. It all has issues in collection. It all has issues in the DNA or the however it's linked, whether it be Teresa or Stephen. You know what I mean? And
Yep.
so each piece of evidence, if you look at it, is not something that Bobby would have needed to move, because each piece of evidence is from collection to testing. It doesn't say what they were able to get inserted into the trial record. It says. But once it's in the record, then it's evidence, even though it never should have been put in the record. And that's so unfair when justice is supposed to be the goal.
Well, and yeah, if the truth is not the goal, then other drivers take control in a
Yeah.
case, and you end up with a different result
And
often, and
yeah.
sometimes it's the wrong result.
And they never, and of course she's not going to mention the elephant in the room, which is the fact that Stephen was wrongfully convicted, and in the midst of suing the county who found most of the evidence but said they didn't really do much at all in the case. They had a peripheral role.
Right.
Yeah.
The
Like,
hypocrisy. You can only take so much of the hypocrisy.
yeah. That's what really frustrates me. Is like no one cares. No one cares about the victim. No one cares about Brendan. And no one cares about the fact that they have done this to this man.
No,
And
they just wanted to end the lawsuit and lock him up, get him out of the scene. Period.
Yep.
I believe that.
And then you have people who act like us who do care are, we're the bad guys because
We're crazy.
we think justice should matter. It's,
Yes.
We think what was done was wrong in this case, because it was. How dare we? How dare we think this is not fair?
That's right.
Excuse me for believing in justice, yo.
Exactly.
Yeah. How dare I? You're right. I'm in a cult. I believe the truth matters and justice should be the goal in the justice system. How dare I? Who do I think I am?
I'm in your boat.
Yep.
All right, continuing on. Yeah, every bone in the body, human body, back to the burn pit on the Avery property undetected. Not according to the photo that Reese took on November 6th. Sorry there, Suckwitz. While the defendant asserts that Bobby planted the key to the victim's RAV4 in his trailer between November 3 and November 5. Oh, crap. Sorry. I got to get back over here. November 3, November 5. The state notes that there is no explanation as to how Bobby could have removed the car from the property without the keys, driven away from the property, walked back to the property, and replaced the keys in the defendant's trailer without anyone noticing. The Wilson test requires that the defendant must provide evidence that Bobby Dassey had the realistic ability to carry out the complicated plan that it alleges was used to frame the defendant. The defendant speculates on many points as to how Bobby could have carried out the plan to frame his uncle, but the Wilson test requires more. I thought we were doing anyway. The defendant has failed to offer any evidence that Bobby had the scientific knowledge to recognize the significance of each piece of the forensic evidence supposedly planted by him, let alone establish that he had the skill to plant the evidence in a way that would stand up to scientific scrutiny by professional crime scene analysis. Or you can't be talking about Culhane. The defendant offers no evidence supporting his claim that Bobby had the realistic knowledge to create and execute an elaborate plan to commit a murder and frame his uncle. The defendant further failed to offer any facts of record that establishes a consistent plan to frame the defendant or any theory including or excluding law enforcement involvement which implicates the defendant in this crime. The defendant's theory that Bobby framed him for this murder also fails to acknowledge a significant fact in relation to this crime to which Brendan Dassey confessed and was convicted of participating in the murder of Miss Halbach. Brendan specifically implicated the defendant in this crime, and his conviction has been affirmed by the appellate courts and remains of record. All the allegations implicating Bobby in the murder and the framing of the defendant are pure speculation and not supported by any evidence submitted by the defendant. As such, the defendant has failed to satisfy the test in Edmonds, Denny, and Wilson. Finally, we've included two other citations besides Denny here. Mm-hmm. Finally, the defendant asserts that the Sawinski affidavit supplies a direct connection between Bobby and the murder of Miss Halbach. Here's the crunch. The defendant asserts that because Bobby was in possession of the victim's RAV4, it proves that he had access to the keys in the defendant's car and her electronics that were found in the burn pit. These items are links that are central to proving Bobby Dassey's involvement in the murder of Miss Halbach. The defendant argues that Bobby's possession of the car provides a direct evidentiary link between Bobby and the crime committed, making him a viable third-party suspect. Assuming, for the purposes of this motion, that everything averred to in the Sawinski affidavit is true, the defendant is incorrect in his assertion that the facts in the affidavit provide a direct link between Bobby and the Halbach murder.
Wow.
Well, I can't disagree with that. Just having a car doesn't prove you killed somebody, but that's the big elephant I was talking about.
Mm-hmm. And let's not forget that law enforcement searched Stephen's house on the 3rd and did like a cursory search of his garage on the 3rd, did all those things and didn't see anything, right?
They were there. They were there on the 4th. I don't.
Okay, but on the 4th, sorry, wrong day. The point being is Sawinski saw the car being moved on the 4th,
early morning of the 5th.
Okay, and the car was discovered right
on the
after
5th,
that. Yes.
that morning.
So whomever brought the car probably brought the evidence with it, because that's when everything, began appearing.
Well,
Yeah.
at least some of it.
Oh no, yeah. And prior to the car getting back on the compound or the salvage yard, there was no evidence seen by law enforcement. And then even after they found the car, they didn't find much until,
7th,
it started trickling in. Yeah.
the 8th was a bonanza day.
Mm-hmm.
That's right.
And when you got 200 cops milling around and they're not seeing it, and then it starts all of a sudden starts showing up. Yeah. It makes you wonder what all them cops are really up to.
Well, and the dog's spending so much time off the property, more time off the property than on it.
Mm-hmm.
Again, to me, you have an issue.
Yeah.
Anyway, moving on. The defendant asserts that ipso facto, if Bobby was in possession of the victim's car that night, he must have also been the individual who committed the murder. No evidence submitted by the defendant supports this conclusion. Even if Bobby was found in possession of the victim's automobile on the night of November 5, 2005, there is only speculation, no evidence to prove that Bobby was in possession of the car or that he had exclusive control over the vehicle prior to that night. That's an interesting way to look at it, I guess. The defendant further asserts that Bobby's possession of the car gave him access to the victim's car key and her personal electronics. Again,
True.
this is speculation by the defendant. Mr. Sawinski's affidavit does not mention seeing Bobby with the keys to the victim's car. In fact, the affidavit establishes that Bobby was pushing the victim's car without power on the night in question, placing doubt on whether he was in possession of the victim's car key.
Yeah, but can we just pause to say you cannot push a vehicle without the steering wheel being unlocked, the steering wheel and it being in neutral or drive. Both require a key to do that.
That's right.
And that's just disingenuous for the judge not to acknowledge that.
She completely threw it. She just took a shovel and buried it. It's like,
yeah.
So what?
Because without the key, you can't move it. Period.
That's right.
Not pushing it. You can tow it on a flatbed, but you're not pushing it down the road without the key.
No, because you got to steer it.
That's right. And you got to get it in neutral.
That's right. All right. The affidavit, now you're fine. The affidavit does not mention that Mr. Sawinski saw Bobby with the defendant's personal electronics. There is no evidence that those items were in the car at the only time that it was linked to Bobby by Mr. Sawinski. Neither the key nor the electronics were linked by any witness or by any forensic evidence to Bobby. The victim's key and the electronics could have been taken directly from the victim or taken from her car at any time prior to or after the murder by another individual long before the auto was in Bobby's possession. There is no evidence of record taken from the car that links Bobby directly to the actual homicide of Miss Halbach. Boy, she said a real mouthful right there. Anyway, we've got, let's talk about 5 pages to go. You want to read a few pages?
Yep, I'll read. The Sawinski affidavit, taken as true for the purpose of this motion, directly links Bobby to possession of the victim's vehicle. However, possession of the vehicle does not directly link Bobby to the homicide itself. That is so interesting when you think about the fact that the only place we have Teresa's blood is in her vehicle. but whatever. Nothing in the affidavit. And if Bobby wasn't, or whomever was pushing the vehicle, would not have a vehicle with the victim's blood in it after the victim disappeared, unless they knew that they needed to get that vehicle into a position for it to be found because a crime had been committed against Teresa. Right?
Right.
Okay. Just checking. However, yeah. Nothing in the affidavit establishes that Bobby was in possession of the evidence that the defendant asserts was used to frame the defendant. Oh. So the car isn't evidence used
Nope.
to frame the defendant?
No. The car is not evidence, but it's the most important piece of evidence there is.
Yeah, because it's what got him the search warrant.
That's right. That opened the door, the floodgates.
Yeah. No forensic evidence was found in the car that directly linked Bobby to the murder. However, side note from Christina, we have DNA on the license plate that doesn't belong to Stephen or Brendan. We have unidentified fingerprints that aren't Stephen and Brendan's in the
And
wrap.
and A23.
And A23. So no evidence of record established that Bobby had exclusive possession of the victim's vehicle prior to the night that Mr. Sawinski saw him on the road. Why else would he have been pushing it unless he had the vehicle or had a knowledge of where the vehicle was and didn't want it found there? I mean, like, are you just not going to think about, okay, all right. Prior to the night that Mr. Sawinski saw him on the road, or that Bobby had any control over the vehicle prior to that date. None of the physical evidence presented at trial or subsequently links Bobby Dassey to the actual commission of the homicide in this case. Okay. While the defendant asserts that the only logical conclusion to be drawn from Bobby's possession of the vehicle that night is that Bobby was the individual who actually murdered Miss Hallbach, that this assumption is flawed. There are other reasons that Bobby could have been in possession of the car that night. Do tell, including that Bobby was trying to help hide evidence to protect the two individuals directly linked by forensic evidence to this murder and convicted of the crime. So by pushing the car back onto the property, you're helping your uncle hide
and brother. And there's no physical evidence on Brendan at all.
Yeah. Wow. Okay. The defendant's conclusory assumption drawn from the evidence offered in the affidavit do not amount to evidence directly linking Bobby to the homicide itself. As such, the defendant failed to meet the final standard of the Denny test to establish Bobby as a valid third-party suspect in this crime. So, all right, so let's go down this trajectory. So he could have been helping them. Wouldn't you want to know?
Well, and not only that, wouldn't you want to not have it on your property?
Well, I'm just saying, as a judge, wouldn't you want to know why he was pushing the vehicle?
You would think.
Yeah, like, let's have a hearing and figure it out.
That's right.
Either he's part of the murder, or he's not. But why is he messing with the car?
Or Sawinski's identified the wrong person.
Yeah, let's figure it out.
That's right.
Let's talk to Sawinski and let's talk to Bobby and see what's what.
And Singlab and whoever else.
Yeah, and the Manitowoc County Sheriff's Department because of the call. Yep. That's good.
Oh, no. We don't want to go down that road. My God.
That's a can of worms. The defendant also alleged that the state committed a Brady violation by failing to turn over the record of the phone call that Mr. Sawinski made to the Manitowoc County Sheriff's Department in 2005. They did. The defendant accurately summed up the requirements for the finding of a Brady violation in paragraph 87 of his brief in chief. To establish a Brady violation, a defendant must demonstrate that the prosecution suppressed evidence, the evidence was favorable to the defense, and the defense was material to an issue at trial. State v. Harris, 2004. I'm not going to list the sites.
No, you don't have to read it.
All right. With respect to the second and third prongs of the Brady test, the court has addressed whether the evidence was favorable to the defendant for the purpose that it was offered and whether it was material to an issue at trial. It was concluded that the evidence did not meet either of those criteria. As such, the defendant failed to establish a Brady violation with respect to the Sawinski evidence. With respect to the statement of Kevin Ramlow, cited in his brief, the defendant notes in paragraph 118 of his brief in chief that this statement was submitted to the court in its motion to reconsider the October 2017 ruling denying his second post-conviction motion. The defendant asserts that this claim should not be procedurally barred under the ruling in State v. Escalona Naranja because the court did not specifically address the affidavit in its ruling on the motion. While the court did not specifically address every document or exhibit attached to the motion of the defendant in its October 2017 ruling, the court considered each filing in full. However, to be clear, the court will specifically rule on the Ramlow affidavit with respect to the defendant's current motion. A Brady violation occurs when the prosecution withholds evidence that is favorable and material to an issue in the case. A Brady violation does not occur when the prosecution fails to turn over the type of information that could form the basis for further investigation by the defense. Harris, Supra, at 15. With respect to the defendant's theory that Bobby Dassey is a credible third-party suspect, the Ramlow affidavit falls into the category of that which could form the basis for further investigation by the defense. Putting aside any credibility issues on the part of the affiant, the affidavit, if taken as true for the purposes of this motion, establishes that the victim's RAV4 was away from the Avery property between the time of the murder and the time that it was discovered on Avery property. As discussed previously, there is nothing in any of the exhibits offered by the defendant that establishes that Bobby Dassey had possession of the vehicle any time before the night that Mr. Sawinski states that he saw Mr. Dassey with it. Nothing in the affidavit of Mr. Ramlow directly links Bobby to the vehicle at the time that it was observed by him. Mr. Sawinski's affidavit only asserts that he saw Bobby pushing the car after Mr. Ramlow saw it parked in a different location. If you don't see the problem with the car not being on the property and then being found on the property, and that then you're not being honest about.
She lied in what she said she's going to address the Ramlow affidavit.
Mm-hmm.
She's including stuff that Sawinski talked about. She's linking them together like they're supposed to go together somehow, and that's not. How is that right?
I know. And then this is a problem for me because there's no exhibit offered that establishes that Bobby had the key to the victim's vehicle. Yes, there is. there's the Sawinski affidavit, because if you don't have the key, you can't push the vehicle.
Right.
So you're being intentionally obtuse about what it takes to be able to move a vehicle by pushing it.
Absolutely.
Because unless you have had a driver all these years, without a key, you can't take the vehicle out of park.
I agree.
Totally. So you're being dumb on purpose. While Mr. Ramlow's information may have been an avenue for further investigation, the exhibits submitted do not directly connect Bobby Dassey to the homicide itself. Okay. And failed to meet the standard under Denny to establish Bobby as a third-party suspect with respect to this crime. Let's also call to remembrance the fact that Bobby said the vehicle never left the property, but yet Bobby's the one seen pushing the vehicle back onto the property.
If we're to believe Sawinski, that's correct.
That's right. And she said, if we are to take what he's saying as being factual.
That's right.
So, yeah. So that's interesting in itself. And failed to meet the standard under Denny to establish Bobby as a third-party suspect with respect to this crime. As such, the failure of law enforcement to turn over Mr. Ramlow's statement is not a violation of his constitutional rights as defined in the ruling in Brady. On May 26, 2023, the defendant asked that the court consider another affidavit from Tom Baresh. In that affidavit, Mr. Baresh attests that on the night of November 4th or the early morning of November 5th, he was performing his duties as a tow truck driver when he observed Bobby Dassey driving a RAV4 on County Road Q. Mr. Baresh states that the headlights from his truck illuminated the interior of the RAV4, and he could clearly see Mr. Dassey and someone that was not the defendant in the vehicle. The affiant goes on to state that while he was incarcerated for bail jumping in 2006, he reported his story to a Brown County Sheriff's deputy who discounted his report. Mr. Baresh then states that he did not discuss what he saw again until sometime in 2016 or 2017 when he mentioned it to his brother. The defendant reports that he received this affidavit on May 10th, 2023, but unlike the Sawinski affidavit, it does not provide any information on whether the statements made in the affidavit were verified or the investigation was completed. Once again, assuming for the purposes of this motion that the facts in the Baresh affidavit were true, the facts do not directly link Bobby Dassey with the murder of Ms. Halbach. The affidavit asserts that the two people were in the car when it was seen driving down the road. While Mr. Baresh states that he can conclusively identify Bobby Dassey in the car, he cannot identify the other individual in the car other than to eliminate that person being the defendant. Once again, the affidavit links Bobby Dassey to being in possession of the RAV4 after the homicide took place. There is nothing in the affidavit that establishes that Bobby had possession or conclusive possession of the vehicle prior to that time. The affiant states that a second individual was in the car at the time that he saw it driving down the road. The affidavit does not establish that Bobby was the individual who was in possession of the key to the car or the car itself prior to that night. The affidavit, only taken as true, establishes that Bobby was in possession of the car on November 4th or 5th. How would he be driving it without the key? However, even by the affidavit statement, Bobby was not the only person in the car that night. Nothing in the statement links Bobby to the homicide itself. One would have to leap to the conclusion that if he were in possession of the RAV4 that night, he must be the individual who committed the murder. As previously discussed, no direct evidence in this matter links Bobby directly to the murder. Furthermore, in this affidavit, a new unnamed individual could equally be implicated as the murderer in this case under the theory offered by the defendant. The unnamed individual had equal access to the car and the key on that night in question. The individual could have been the individual who, if the defense theory is correct, could have moved the car back and forth from the property, removed the personal electronics from the car, possessed the key, and then planted it in the defendant's home. As such, the affidavit offered also fails the test in Denny to be admissible to prove the existence of a third-party suspect for this crime. In the alternative to his motion under Denny, the defendant asked that the court grant him a new trial in the interest of justice pursuant to Wisconsin Statute 805.15. Given the above conclusions reached with respect to the evidence offered by the defendant, there are no legal grounds to grant such a request. For the reasons set forth above, the motion of the defendant is denied. Barf.
Go.
Yeah. Wow.
No doubt.
Yeah. I mean, like, finality, right? That's what this is about.
Absolutely. Finality. Always. Always about finality.
Which finality, when it's clear injustice, it makes a hypocrisy out of justice.
Well, she took several leaps herself.
Yeah,
to me, she did. She had to have taken multiple leaps to come to some of the conclusions that she did, because she completely ignores the very fact that whoever, according to Sawinski, someone had possession of that car, and that's a problem. And well, he can't prove he had the key or any electronics, so they don't matter. She went to great lengths about completely ignoring that the RAV4 itself is the major piece of evidence.
Mm-hmm. And you got to have a key in order to move it, whether you're pushing it or driving it.
That's right.
So,
no choice.
And if she wants to pretend like she doesn't know that, then
maybe that's why she's no longer on the case.
Yeah. Terrible. Absolutely terrible.
There was a photo I'm going to show here. I'm trying to find it.
So, are there any open motions before the court?
The only thing that's open now is the request for review or petition review to the Wisconsin Supreme Court.
Okay.
And that was toward the 1st of February, I think. And then, of course, the memo that we read from Calling Comfort last night. There
And what is that? That's them trying to keep them from reviewing it?
Yeah. They're basically said, it's just a waste of time. Don't bother. There's nothing to see here, so don't bother reviewing anything. Anyway, I've tried to keep up with any questions. There's been quite a bit of conversation, but I tried to grab anything that was a question. I think I got everything, but we'll see. Um, JD says if if it were law enforcement pushing the car, no wonder all no wonder that call was buried.
Mhm.
Well, I can't disagree with that. To have taken to as long to get it as it did is a real problem for me. If there's no problem, you just turn it over, you know. Let the defense run with it if that's if that's what they're going to do. Okay. Next question is from under. Let me get this here. Under your scar says, works someone have a record of the family cell pings at the time?
I feel like the only people we really have cell tower stuff for is Stephen, Teresa, Scott,
Bobby?
and Bobby.
Yeah, that sounds right. Yeah, the phone records that they got at Barb don't have. That's the oddest phone records. They're not like any others in the case at all. They're so jacked up. So, and they were never graphed out. Nothing. It's just
And
that no.
it's interesting. In the YSL case, they're still creating spreadsheets in the DA's office
Oh my
and
God.
using them and presenting them as phone records. I feel like if there should be a standard
There should be.
of like what records should be for court cases, and they need to be non-manipulated by anyone except there should be like a guideline for them to be utilized as evidence, because having the DA's office create reports that can be created slanting it to look a certain way, and if the defense doesn't know enough to catch them and bring that out, it's basically making evidence, a square peg fit a round hole.
Well, yeah, when the state manipulates phone records or any kind of record, but talking about phone records like they did, they were highly manipulated because what was shown at trial was a partial bill. It was not a record from the full bill, and to me, it's a real problem.
Mm-hmm.
There could be other calls in there that didn't get included.
Yep. And then the fact that, they didn't pull the text message threads. They didn't. There's just so much that wasn't done. And
yeah, we're fixing to get to another question that's going to go a little deeper into what you're talking about right now, and I'm going to put it up. This is from Mr. Precedent. Were any phone calls made to from the under-home phone while the computer searches and downloads were happening via dial-up on the same line? No, you can't do that. If you guys are anyone that's been around long enough, unless you had a second phone line when you dialed out from your computer to your ISP to get on the internet or whatever, that phone line was busy.
mm-hmm.
And you couldn't make a phone call or do anything else on it. If you picked up a hand receiver, you would break the connection. So I remember that very well.
Oh yeah,
yeah. And they didn't have like a modem box type hookup. they did use the phone line. So, and even into, I mean, by the time, I mean, a lot of people had moved to cable, but they didn't have that, but they did have access through the phone line. So, no, absolutely no. There's absolutely no way that somebody could have called out. And for people that had call waiting and that kind of thing, I know that in my computer I had well, it was a little app or whatever, but when it dialed out, it would dial *70 that would disable the call waiting. So even if somebody called, all they would get's a busy signal. It had to be disabled because it caused a lot of issues. You'd get disconnected, blah blah blah, because of depending on what you had on your phone. So,
Wow.
unfortunately, yeah,
brings back memories of dial-up. It was so slow.
It's terrible.
So slow.
It was terrible.
Yeah, we've come so far. I mean, internet was still slow in like 2015.
Oh no. We moved. Just a little side history about me. We moved from East Tennessee to Western North Carolina in February of '99.
Mm-hmm.
And anyway, we got an apartment, pretty big apartment, a few miles from where I worked at. Anyway, back then we had charter internet, but we had charter cable, but the internet was supplied by At Home. And I don't know if a lot of people remember At Home, but it was great. It was blistering fast for the time frame. It was, well, I couldn't believe it. There was one of the new Star Wars movies was coming out, and there was a trailer. It was 50 gigs for the trailer, and I downloaded it in like no time. It was crazy fast. I couldn't believe it.
Well,
So depending on where you lived,
let's be clear. Internet in Gainesville, Florida in 2015 was terrible.
Okay. I can go with that.
Because when you would try and watch a show, it would buffer.
Oh no.
Yeah, for like 40 minutes of buffering would allow you to watch 5 minutes, and then it would buffer for another 40 minutes, and then you could watch for 5 minutes.
Wow.
It was awful.
That's unwatchable.
Yeah, well, unless you were dedicated to watching and willing to wait.
Well, true, but that would make it so unpleasant to watch because my God.
Because I used to do it for the Walking Dead episodes. What I would do was I'd watch the 5 minutes, and then the 40 minutes that I'd wait for the next 5 minutes, I'd have a project. Like I'd do the dishes, I'd vacuum, I'd do a load of laundry, I'd put it up. Like, I would clean my house on my day off, and I would watch the episode of The Walking Dead from the night before, because back then I didn't have AMC. And so I had to watch it online. And it was
painful memories.
Yeah.
That's great, man's life.
Yeah,
no doubt.
I agree.
All righty. I put this photo up, and I have to thank you for you're so instrumental in getting so many things that we didn't have. And this is, of course, the photo of it shows the back of the rab that Christina got from the medical examiner.
Yeah.
Pfizer. That shows,
interesting fella.
Yeah, I don't know if you can see my cursor or not. I don't see it on. No, but if you look down at the bottom of the seat and down at the floor, you can see this lug wrench that comes from emergency roadside kit. I was thinking about that earlier, and I thought, hey, I'm going to put that up today for our ending photo. But this response from Judge Suckowitz blew me away. I know it did a lot of people in her aspirations to completely downplay the RAV4 is the piece of physical evidence, the most important piece, but it doesn't matter if someone had it. It doesn't matter who it was. It doesn't matter if it was Bobby. It could be anyone
Mm-hmm.
of a missing person that later turns up. Well, I mean, I believe it that she's dead. She was killed. Um, and it not be questioned. You don't want a hearing to get these things sorted out. Potentially having a couple of people locked up that shouldn't be locked up. It's banality, as you said. So anyway, that nauseating thing is done again. But I thought it was a timely and good time considering everything that has transpired, and then being before the Supreme Court now, and she dropped the case. That's another really. I just cannot understand at all. I just can't. I've tried. Anyway, we've been at it just over 3 hours, Christina. You have any final thoughts, words you want to get out?
Just that I'm just going to pray this new judge is a little more justice driven and not so much finality driven.
Well, if it ever lands back in his court, hopefully.
And maybe these Court of Appeals guys who get this will
You mean the Supreme Court?
or yeah, whoever it is, wherever it's off to next, just I genuinely pray this case gets in the hands of people who want the truth out and have the backbone to do what it takes to right this ship. If and I mentioned this briefly last night, let's just start with Brendan.
Absolutely.
Let's even if you believe the hype about Stephen, reopening this case even for Stephen will allow a potential avenue for getting Brendan out.
Absolutely.
And so if you need a valid reason to do it, think about the 15-year-old kid that was served up on a platter to make a case that clearly happened nowhere near like his confession said it did.
He was served up like Thanksgiving dinner.
Yes, he was.
Yeah.
And if you have children and a heart, that has to get to you once you realize that.
For some people, it doesn't. They think he's guilty as crap, and that's just the end of it.
I don't believe that, but
and some people believe that maybe he had something, but he served enough time. What?
Yeah.
If you believe he's guilty and he participated in this horrific crime and all this violence, why would you want him loose at all? And that didn't work for me either. Alrighty, well, it's that time. I am hungry. I haven't eaten dinner again. I did enjoy mine, last night. But
what'd you have last night?
It was this. It was like, I don't think it was sirloin. It was some kind of steak that was stripped up, cut in strips and marinated over rice.
My nephew's
seasoned rice.
Oh, that sounds good. Actually,
yeah.
My nephew's birthday, he turned 8, was today, and he asked me if I would. He wanted to go to the arcade, so they took him to Dave and Buster's So I went with them there. And that we had lunch, and I brought that what I had. I brought it home. I had that. But that being said, I think I'm going to try and make these fried chicken mashed potato bowls this week. It looks so amazing. Have you ever had anything like that? Even if
I have
it's
not.
pre-made?
No.
Yeah. Well, I'm going to try it. And if it's simple and it tastes good, I'm going to send you a picture because I think you'll like it. You
Yeah,
like
sounds
fried
good.
chicken?
I love fried chicken. Oh my
And you like
God.
mashed potatoes?
Oh my God. I could live on potatoes.
Yep. Yep. Me too. And it looks pretty simple. So I was thinking about trying that this week.
Yeah. Heck yeah. Yeah. Let me know.
Yeah, and the weather, it's not it's nice during the day, but for Florida, it's still kind of chilly at night. And so, I like comfort food.
Yeah. I think it was 12 degrees here last night.
I can't say it was that cold, but
But
it's still getting in the 40s.
it got in the 30s. I think it's supposed to warm up a little bit and then turn cold again. But yeah, our heating has went up. First of the year, it went up almost double. I mean, it was cold in January. It was cold in February too. But I was shocked when I got our power bill last month and the month before. Literally almost doubled.
Wow.
Probably did double. I mean, it roughly cost me $18 a day to heat our home. And I'm not talking about we don't run our we rarely ever turn it above 72. Now, if it's zero outside, yeah, we might have to kick it up because it's pretty good sized house. And if you
Mhm.
don't, it's 65 degrees in the house. So, but that's rare. Most of the time we keep it on 70 or 71.
Yeah.
Crazy. Anyway, I don't know what caused that, but
It's
I'll be glad.
interesting you said that because I've had, we're remodeling where I stay at. And my light bill should not be much at all. But mine went up like $60 last month as well.
Yeah, you don't want to know what my power bill was. I'll tell you if you want, but you're not gonna
Yeah.
like.
What is it?
The one I paid for January was
Oh
$640.
my goodness.
I told you it's about 18, 20 bucks. Well, it's actually over $20 a day in January, and it's close to that for February. I was
Oh my
shocked.
goodness.
Yeah, not
What
kidding.
what's your square footage?
That's about 20. I mean, with everything, the downstairs and upstairs, it's about 2,600 square feet.
Okay, so that's a decent size house,
Yeah,
but
it's pretty big. It's pretty
still,
big, but it's pretty well insulated. I mean, it's a nice house. We don't have
yeah.
any big gaping. I mean, it's a little drafty in the room that I stay because
Hmm.
of the number of windows and so forth. But even then, it's still not that bad. It's crazy.
Yeah, that's wow.
Yeah,
But it's been so cold too. Y'all
it
have had
was
some
cold.
good cold, some,
January it was cold,
yeah.
and so February is pretty cold too. So anyway, all right. Well, I'm gonna get us out of here and get some chow.
Okay.
I want to thank. I mean, we had quite a crowd tonight. Several from X watching as well. A few from
Awesome.
Facebook. A few from Facebook. Um, Certainly like to thank everyone for joining in and going through this
Yes.
again. Not sure, if anybody has suggestions because we're in this limbo land of not having anything really new to talk about. I'm glad to talk about pretty much anything, whatever it is in the case. There's so many avenues. If anybody has an idea, hey, please let me know. Doc's covering, Brendan's case. He's going to get into, you know, the rest of what we've been talking about, and I think he's probably going to move forward, going into the post conviction stuff. We've already talked about some of that, But we have the O'Kelly document from June 2009, the ex parte hearing, and that was preceding the hearings in 2010. So anyway, again, if anybody has any suggestions, let me know on Discord or leave a comment. After the video publishes this one, and I'm glad to take a look. With that said, I'm going to tell you all, it's been great. I hate this particular document, but this has been a Foul Play production.